On April 27th, 2 days ago, Mark Lehman and Stacey Liani, did I butcher that? Liana, filed Richard Allen's reply brief in the Indiana Court of Appeals. 58 pages of Frank's challenge, 7 evidentiary rulings, a Napui claim, and a 13-month story about the state of Indiana and a man that broke. Tonight, we're reading the whole damn thing. This is Defense Diaries. Good evening or good morning, depending on where you're at in the world. I'm Bob Mata. This is Defense Diaries. And as always, I am joined by my beautiful and brilliant co-host, Allie. What is up, girl?
Hey, babe. Hey, all.
So,
it's been a lot, you know. So you'll see. I started to highlight. Well, first, why don't you give everybody like a quick, where we are in the appeal right now.
All right. So essentially, where we're at now is the appellate brief filed by Richard Allen has been filed. The state responded, and then the defense gets an opportunity to reply to the state's brief, and that's exactly where we're at.
Right.
So Allen was, if you guys don't know anything about the case, Richard Allen was tried in late 2024 in Carroll County, Indiana. He was convicted of the homicides of Abby Williams and Libby German. He was sentenced to 130 years. He took to his direct appeal right to the Indiana Court of Appeals. His brief went in months ago. And then the state, they filed their response. And on Sunday, well, actually, Monday, right? 2 days ago, Allen's appellate team filed this reply brief. Of course, Allie and I are getting ready to leave for New Orleans in the morning. So, timing is everything, as always. True crime never sleeps, so. And, for us, this case never sleeps. So,
right. And, the brief it's doing all the things. It's a reply is your closer. You are not introducing new arguments. You are answering everything that the state said in its brief and tightening the arguments you already made. If you are appellate counsel, this is the document. When you decide what the panel is going to, the appeal panel of judges is going to be thinking about when they retire to write. So I was contemplating not reading the entire brief at first, but tell the people why we need to read this brief.
Because every damn word matters. That's why. Every damn word matters. There is no fat. It's all meat. And we got to read every word of it. I mean, when they're coming in asking for the extra words, they are not wasting one word. And it's powerful. It's powerful. My dear friend, Michael Osbrook, per usual, always has a few criticisms, but by and large, it's a phenomenal brief.
Yeah, it's genuinely well written. Bob was literally crying just reading the summary.
Why do you throw me on?
I mean, it's what happened. Like me and him alone in the room.
It anyway. Everybody knows I'm a crier.
He's all choked up. He couldn't get the words out, but it's genuinely well written. And the experience of reading good appellate work, it's part of the lesson. The structure, the cadence, the way the appellate lawyers move from law to fact and back, that's a craft.
Yep.
And in this brief, it's a master class. There are passages that hit harder when you hear them than when you read them, for sure. So we're gonna read it together. What are like the big general overview, babe?
Yeah, and before we get into that, I set a goal tonight and I'd like to hit it. The grift is in full effect tonight, so make it happen.
It's what I'd concert like tickets.
Yeah, I mean, among other things, like paying the lights. But what I'm going to do is, if we hit the goal, I don't know if you guys have watched that Lucy Studi, Don Studi, Green Hollow Killer thing. And I don't know if you know that I was like boots on the ground with Lucy Studi, like in my ear for like a year and change. I want to give you all kind of like the heads up. Like, I'm going to tell you kind of like the beginning of that story, how that thing worked out, because it's an insane story and it's an insane case. And I don't even know if it is a case. So hit the goal so I can tell you all about that.
All right.
All right. So, I mean, basically, there's three big substantive clusters. First, there's an attack on the search warrant, okay, which authorized everything that came after it, which the brief is alleging was built on bullshit, falsehoods, material omissions, all by Tony Liggett. Second, there's an attack on the confessions, which are framed around 13 months of pretrial solitary confinement. Oh, no, I'm sorry, a single man cell. And a state that the brief says actively cultivated those statements. Third, there's the multi-issue argument that the trial court systematically excluded defense evidence, sketches, expert testimony, the third-party suspect evidence, which we all know, and the audio of Rick Allen in his psychotic episodes, phone calls that bookended his confessions. That's that completeness doctrine thing that they were arguing so hard about, where he's calling his father, stepfather, Ken, 2 hours before he's calling Kathy and saying, I did it. Well, I guess I did it. Apparently I did, that kind of thing. So plus there's a Napui claim about Brad Weber's testimony, the white van. Plus there's a cumulative error argument tying it all together.
Right.
So
and,
that's
just
30,000 foot view.
right. And to be just a little more to expand on those clusters. So Allen argues that the trial court committed reversible error by admitting the evidence seized through the unconstitutional search warrant, like he says. So he contends that Detective Liggett included deliberate falsehoods in the affidavits, such as misrepresenting witness statements and omitting exculpatory evidence that would undermine probable cause. So he maintains key witnesses. Blair provided a sketch and a description of Bridge Guy that did not match Allen, but was deliberately withheld from the judge who issued the warrant. He challenges the admission of his confessions, as Bob said, arguing they were obtained through coercive state action. Again, being held in a maximum security solitary confinement for 13 months as a pretrial detainee is a big deal, during which time he developed severe psychosis, lost 40 pounds, engaged in self-harm, and was involuntarily medicated by a state that says, nothing was wrong with him. We involuntarily medicated him, but, nothing to see here. So Allen contends that the state exploited his deteriorating condition to extract the confessions that were not voluntary. The brief details how Allen was eating his own feces, experiencing delusions, unable to remember making confessions shortly after giving them. And additionally, they argued the trial court denied him his right to present the complete defense, excluding critical evidence, including Blair's sketch that showed Bridge Guy did not resemble Allen, expert testimony about ritualistic aspects of the crime scene that the state had previously investigated on their own, and then evidence of alternative suspects that flowed from that very investigation with connections to one of the victims, expert testimony challenging the reliability of the firearms identification methodology. And Allen further contends that the state knowingly presented the false testimony about a witness timeline that was used to corroborate Allen's confession. That's what Bob just talked about as far as Brad Weber. Sometimes I like to mix these people up. So,
I mean, there's a few Brads, at
right,
least two Brads of note.
right. And then, obviously his confessions, and he's requesting that the Court of Appeals reverse his conviction, arguing that these errors individually or cumulatively denied him a fair trial. So, babe, what do you think matters most when we're looking at this?
Well, I guess strategically, the door before all of those doors is preservation, right?
Yep.
And the state's brief, based on what the reply tells us, leaned hard on the waiver. We had two pretty lengthy debates with you, Andrea, and Osbrook being the white hat, the state. And Osbrook had a pretty easy argument in his estimation in terms of the waiver, meaning that because the defense failed to object at trial as to certain issues that they believed were either going to be ruled upon improperly prior to trial, or they were not objecting to things that were coming in at trial that had previously been litigated, which is really where the preservation issue lives in terms of this reply. And as we get into it, you'll see what they're talking about. Because the state was saying it wasn't preserved, it's dead. They don't even have to get to the merits of the appeal or the brief because they screwed it. They didn't object at trial, and you have to do that in order to really preserve the issue. So what's happening here is that the defense is having to push the door open before the panel even looks into the merits of the case. So watch out for that. We're going to get into that right away. That's really the first thing that they're going to address when we get into this. It's a very powerful argument. Allie asked me if, Michael wasn't aware, which I'm sure that he is, about that change to Rule 103B.
Right. So there was a change to the Indiana rules of evidence, specifically this Rule 103B, to match the federal rules. And that amendment, which typically rules are not, they're not retroactive. They don't go backwards generally. So, they're making an argument that this represents what the law was, and we'll hear it when we get to it. But it's not even effective until July 1st. It was like written and finalized in March. So
right,
that
it's the
amendment,
retroactivity thing is where, if the state, remember the state's done though. Like there's no more responding from the state at this point.
Right.
All they can do is appeal it up to the Supreme Court of Indiana or Indiana Supreme Court if in fact this thing is reversed and remanded.
So that amendment says a definitive pretrial ruling preserves error for appeal without renewing the objection at trial. So the defense in its brief actually invokes that amendment twice, and we'll see it when we get there. So, it's a real world example of appellate lawyers using a not even in effect yet rule as persuasive support. And that's the kind of move that, an appellate practitioners make all the time. And it's worth seeing. But I do think that there is some support in Indiana law. I did do like a little bit of research, and it seems to me like there is a lot of support for the argument that Indiana's what was I saying? That
I don't know. What were you saying? Did you
that
send
Indiana's
me the highlighted brief, by the way?
I did. That Indiana's, retroactivity doctrine is well established and strongly favors applying new rules to cases pending on direct appeal. So there's some cases that hold that a new rule for the conduct of criminal prosecutions is to be applied retroactively for cases pending on a direct review and that are not yet final. So there are some times where that they have done that, and they there's a case, I think it was Smiley v. State, where they affirmed the principle that retroactive application of new rules to cases on direct review remain subject to the standard rules governing appellate procedure.
I want you to revisit this after we get through that section, because I think it'll make more sense to people when they kind of hear the argument in terms of the retroactivity. But, we've got a little bit to go before we get to that. So I'm going to pull it up. Is that cool?
Yep.
All right. But I do want you to revisit that.
Okay.
So that there's context for the folks out there. All right. I did in fact get your highlighted version. Thank you.
And just so you guys know, at some point I stopped highlighting because literally there's not a word wasted. So,
I told you.
I know, but you were like, highlight it. Oh.
Wait, here, Michael's popping off in chat.
What's he popping off about?
Smiley was Blakely, not an effing trial. Oh, he almost said the F word. Oh, Michael.
What's he saying? Smiley is what?
Was Blakely not an effing trial rule?
Oh, well.
Michael knows what he means.
I'm trying, Michael. I'm trying. It's something. Right. No?
I mean, are you talking to him in chat?
Yeah. I'm like,
all right, you guys.
I mean, there's like this Rodriguez. What about that Rodriguez versus state?
Why don't you all bicker via text? I'm going to start this.
The 2026 case.
All right. So this is the summary of the arguments. And I mean, they lay them out beautifully. Like this is like, I was, I'm reading through it and Allison was laying on the bed and I'm like, I have to read you this. And I couldn't even get some of them out. It's, but I'm a softie. All right. So this is the summary of the arguments. The first is the unconstitutional search. Okay. All right. Let me pull this comment off. And y'all, we're going to leave your questions to the end. We will not answer them. Per usual, we will definitely go through them. Actually, you start with the reading, babe.
Okay.
Is it big enough for you?
Yeah, I'm just going to start with the summary.
Oh, somebody in our chat last night said that it was cringy when I called you babe.
Well, it's what we do.
Yeah, you know what? I told that person to go fuck themselves. So sorry.
Come on. I almost said, come on, babe.
Yeah.
I mean, I call him babe probably more than he calls me babe.
I got you, babe.
I got you, babe. I mean, I say, hey, babe. Hey, all. All right. They might have been talking about me, not you. All right.
I don't care which one of us they were talking about.
So I'm looking at my screen, not yours. So you are at this.
I'll stick with you. I'll scroll.
I just want to make sure you were at the summary.
Yeah, unconstitutional.
All right. So this is the summary of the argument. Unconstitutional search. The trial court committed reversible error by admitting evidence obtained through an affidavit built on deliberate falsehoods and material omissions. Detective Liggett falsely swore that witness Carball gave an incriminating description, quote, in 2017, and that Allen admitted wearing matching clothing. Neither was true. He simultaneously concealed Blair's eyewitness description, which excluded Allen and his vehicle, withholding from the issuing judge the very evidence ISP had validated in a 2019 press release. The pattern is unmistakable. Every fact undermining Liggett's theory was omitted. Every fact supporting it, however distorted, was included. Strip away the falsehoods and restore the omissions, and probable cause evaporates. Because Allen exhaustively litigated suppression below, his challenge is preserved.
Well summarized, yes.
It's very well summarized. And then, do you want me to keep going?
Yeah.
Unprecedented confinement. The trial court committed reversible error by admitting confessions the state extracted from a man it broke. Law enforcement interrogation is not required for coercion. Prolonged solitary confinement on a severely mentally ill detainee plainly qualifies, especially where law enforcement, upon learning of the inmate's grave disability, doubles down and starts collecting confessions. The state's attempt to reframe Allen's 13 months of maximum security isolation as routine custody cannot be reconciled with IDOC's own policies, the IPAS litigation, or the unprecedented harshness of Allen's confinement. The state failed to prove beyond a reasonable doubt that Allen's confessions were a product of rational intellect rather than their deliberate indifference to his mental health. Unfair trial. The criminal defendant has a federal and state constitutional right to present a complete defense, and evidentiary rules that exclude critical defense evidence on grounds disconnected from the rule's purpose violate that rule, citing to a U.S. Supreme Court case, Holmes v. South Carolina. The trial court's ruling on 7 categories of defense evidence violated that rule. The state's brief argues at length that the evidence against Allen was overwhelming, but the state's case was a paper tiger, and the trial court systematically barred Allen from lighting a match.
Tasty.
Let's say it again. The state's case was a paper tiger, and the trial court systematically barred Allen from lighting a match. The jury never saw the sketch that proved Blair did not see Allen. It never heard the ritual explanation the state itself once pursued. It never heard the scientific critique of the unreliable methodology that produced the firearms match. It never heard evidence implicating 2 named alternative suspects and law enforcement's failure to investigate them thoroughly. That one makes me want to scream because I'm like, why just two? Why are we just saying two? There's the guy that confessed. There's two guys that confessed, I think, but okay, it never heard the audio of Allen's psychotic episodes, the bookend calls, and clinical observations that would have impeached his confessions, or the unimpeached phone data that contradicted the state's timeline.
Attack the
Each
timeline.
Attack the timeline. Each ruling was reversible error standing alone. Together, they kept Allen from setting the state's case ablaze and denied him a fair trial. I'm going to say that one again. Each ruling was a reversible error standing alone. Together, they kept Allen from setting the state's case ablaze and denied him a fair trial. Compounding these errors, the state knowingly presented false testimony from Brad Weber about when he arrived home on the day of the murders. Testimony the state's own FBI subject information sheet refuted, and then exploited it in closing as a, quote, act only the killer would know. When Allen attempted 6 times to correct the falsity, the state obstructed every attempt, citing to Napui. And
There
it
you go.
requires reversal.
All right. So if those argument summaries don't get you ready to dive into this reply, I can't help you. I can't help you. All right. So I'll take over on argument 1. So
Yeah.
Yes. Yes.
I had like a little summary. I don't know if we need it.
You can do it. You can do it.
So
I mean, it's pretty well summarized in the brief itself, but
yeah, it's fine.
Well, let's hear one, and I'll tell you if I think that I'll vote. We'll all vote whether we
Wasted
need the
work.
summaries
All right,
after we read argument 1.
Allen argues that the trial court erred by not holding a Franks hearing because Detective Liggett's warrant affidavit contained falsehoods and omissions made with reckless disregard for the truth. Specifically, Liggett misrepresented witness Carball's statement about seeing the muddy and bloodied man in a blue jacket in 2017 when she actually described a muddy man in a tan jacket. Liggett also omitted Blair's description of bridge guy that did not match Allen's appearance. Yeah, I'm not going to do those anymore.
Yeah, I mean, redundant.
Yeah.
All right. Okay, so
I do wasted work sometimes.
yeah, I mean, I get where you were coming from with. All right, so Roman numeral 1, the trial court committed reversible error by admitting evidence seized from the unconstitutional search and denying a Franks hearing. A, Allen's exhaustive pretrial litigation preserved the Fourth Amendment issue. So this is going right to the waiver. So the state contends that Allen waived his Fourth Amendment challenge by stating no objection when individual exhibits were offered at trial. But the argument fails on 3 independent grounds. First, the purpose of the contemporaneous objection rule was fully satisfied. The overriding purpose of the requirement for a specific and timely objection is to alert the trial court so that it may avoid error or promptly minimize harm. Okay. Courts should not apply the rule with unyielding rigidity. Okay, when this purpose has been met.
And that I think is the strongest argument here. And I think it's propped up by, and maybe Michael will chime in, the change in the statute that they're about to get to. But we said this, at least I think that Andrea and I both said that the purpose of the rule is not at issue here, because this stuff was thoroughly litigated. The issue was brought to the court. The issue is on the docket, on the record, although not the actual trial record, but this case record for the court to review.
Back to the body, as Allison likes to say. So Allen's attorneys exhaustively litigated the suppression, filing multiple motions supported by more than 130 exhibits. The Franks. After the court denied the motion to suppress without a hearing, Allen renewed it twice more, with the court again, which the court again denied without hearing. Throughout the extensive briefing, Allen repeatedly emphasized Liggett's omissions of Blair's description and the falsehood about Carball. Allen did not, quote, idly sit by, only to cry foul when the court ultimately renders an adverse decision. And I'm not going to, I'm going to skip the sites, for if you guys want to see them, there's the table of cases that are before it, just in terms of kind of fluidity and expediency. I'm going to skip the citations. Allison may read the
I
cases.
just
but-
might say quoting into an Indiana case, whatever, something
Okay.
like that.
So there is absolutely no strategy for Allen's attorney's failure to object to evidence that they so aggressively litigated. For judicial efficiency, the issues should be resolved now rather than on post-conviction relief. So second, the recent amendment to the evidence rule 103B confirms that Allen's challenge is preserved. The Indiana Supreme Court amended Rule 103B to clarify that, quote, once the court rules definitively on the record, either before trial or at trial, a party need not renew an objection or offer of proof to preserve a claim for error for appeal.
So let me
Claim
just
of error
stop you
for
there.
appeal. Yep.
Do we think that the court definitively ruled on all of these issues? Because a lot of motions in limine are fluid. Like you can, if something happens differently at court, you can raise it again. So, I mean, we'll just have to see.
She ruled definitively at some point on all the Franks,
Yeah,
denied without hearing.
yeah. And
I
they're
mean,
gonna have, there's existing federal law on what constitutes a definitive ruling because this is now following the federal rule. Um, and that was always, I think, hotly debated in federal court since the rule has been, you know, uh, since it's been there. But the Seventh Circuit authority that predated the rule, it was that you got to make it a contemporaneous, some sort of contemporaneous objection at trial. You've got to bring it up. But now that the new rule is in effect, it's so that's where they're going to find authority when it comes down to it for interpreting um, what is a definitive ruling. Because I know there's a case from 2000, which was like right after the rule, I think the federal rule, where they said that a party offering evidence excluded by a pretrial motion in limine must still offer the evidence again at trial when the in limine ruling was tentative. So I don't know how much tentativeness that she had in her rulings, but you know that's all I got to say on that.
well, so this is an interesting comment. Sinbad Sailor says Bob Gull said the defense could bring forth evidence of a nexus right up until the end of trial. And I do remember saying that. However, she barred any kind of mention of third-party culprits. So I don't know how they were supposed to do that.
Right? Yeah, she barred them from saying any of the words that could have gotten them.
Or you can create a nexus, but you can't talk about any of the people or any of the things that could potentially create a nexus. So good
Right.
luck with that. Yeah, that's a failing argument by the state if they're going to try to make it an oral argument. But all right, so where was I? Okay, so this includes a ruling on motions in limine. The state urges this court to ignore the amendment because it was not in effect at the time of trial. But because the rule governs what is required on appeal, it should be applied to Allen's pending appeal. At minimum, the amendment reinforces the DRC principle that the contemporaneous objection rule must not be applied with unyielding rigidity. Okay, so third, the Franks hearing denial is a pretrial constitutional rule requiring no objection to preserve. The trial court did not merely admit evidence, it refused to hold a Franks hearing, and that comes from Franks v. Delaware. Once the ruling was made, no further objection at trial could undo it. The state cited no authority requiring a defendant to object at trial to preserve the denial of a Franks hearing. All right, babe, you can take B. We'll alternate.
Right. And I just want to say when we talk about there's some, or at least when I was trying to argue, and as a defense attorney, that's our job, right? Try to make the strongest argument for some sort of retroactivity for this rule. And we'll keep an eye out for Michael's comments. But, in Indiana has a, a, a like a doctrine on this. I don't think it's like quite a Hail Mary. So in 1992, the Indiana Supreme Court announced a new evidentiary rule in a case called Lannon, abolishing the depraved sexual instinct exception. But at whatever, the court used the language effective from this day forward, so clearly prospective. But in a companion case that day, the court turned around and applied the new rule to that case already on appeal. So that's where I'm saying there might be this difference where you can argue that a case that's on appeal right now maybe gets to use that new rule, and the Court of Appeals followed up in other cases, and they reversed convictions on direct appeal under that new rule. So to me, the new evidentiary rules announced by the Indiana Supreme Court apply to all cases pending on direct review, unless the announcement itself contains language confirming the rule. It doesn't apply there. So I mean, that's the argument that I would make, and that Rule 103 amendment doesn't say anything that makes it not applicable to cases that are on appeal right now. It has an effective date, but that's not the limit. And the rule could apply to all appeals pending at the time that the rule takes effect. So I guess the rule isn't even in effect yet, though. That's part of the problem. So Allen's appeal will not be decided before July. So at the moment, the Court of Appeals actually conducts its analysis on whether Allen's preservation was adequate. The new rule will be governing that analysis. So that's my retroactive application argument. And I think there is some support for it in Indiana law. And again, I will await Michael to tell me bullshit.
Which he will, if it is bullshit.
Right. It's Lannon, I don't know, Pernat, Pirnat, and Sink. They are this body of cases where they applied this rule, even though it wasn't in effect during the trial, but it was in effect at the time of the appeal. So there you go.
All right, go. B.
Oh, me?
Yep.
B. Okay. B. Detective Liggett included multiple deliberate falsehoods in the affidavit. And babe, keep an eye out for Michael's comments.
Okay.
The state argues that Liggett's representation of Carball's account that she reported seeing a muddy and bloody man wearing a blue-collar jacket was not a false statement, and that any inaccuracy may have been a mistake. This argument also fails. Liggett did not just represent what Carball said. He represented when she said it, swearing she gave her description, quote, in 2017. The temporal representation added a veneer of reliability because a description given close in time to the murders carries obvious weight. The state concedes that in 2017, Carball never described a man as bloody or as wearing a blue jacket. She described him as muddy and wearing a tan jacket. The evolution of Carball's statements made the affidavit more misleading, not less. That Carball's account changed over the years from muddy to muddy and bloody, from tan to blue, is precisely the kind of information the issuing judge needed to assess her reliability. And they cite an Indiana 2016 case for the proposition, quote, police officers seeking a warrant should provide the magistrate or child judge with all information at their disposal concerning a source's reliability. Now, I'm going to pause right there. And here's another thing that I think reinforces that argument. And let's think about like Brady, Giglio materiality. Detective Liggett's omissions from the search warrant affidavit could be evaluated under the Brady Giglio materiality standard, which recognizes that a witness's credibility information is so essential that it must be disclosed as exculpatory material at trial. That's how important they find it. So I think that this argument buttresses the argument that the defense is making right here, because Blair's description excluding Allen as bridge guy constitutes the same type of credibility undermining evidence that would require disclosure under Brady and Giglio if presented at trial. The omission of this information deprived the magistrate of highly relevant information that tends to undermine the warrant's credibility determination and probable cause finding. And then, because the magistrate had no meaningful opportunity to exercise discretion regarding these omissions, the warrant, process was fundamentally compromised. And I do think that Brady Giglio kind of argument makes this even stronger, makes the state's argument, the defense's argument, even stronger, that if this is evidence that would have been required to be turned over to the defense because it goes directly to her credibility, how the hell can they say it's meaningless as far as what the judge needed to know in the when deciding whether to issue a warrant? So that's what I think.
Strong.
All right. So
All right. So
returning to the body.
Yes.
Instead, right, Liggett only included the version of Carball's account that fit his conclusion and falsified when she gave it. It's also implausible that Liggett made an honest mistake. Liggett was the officer who interviewed Carball in 2017, and Liggett also omitted that Blair did not believe she saw the same man Carball did, resulting in a 2019 ISP press release that the man Carball saw was not Bridge Guy. This is no coincidence that the false statement and the omission both bolster Liggett's new conclusion that Blair and Carball both saw Bridge Guy. The Carball falsehood is not the only one in the affidavit. The state does not dispute that Liggett falsely stated in the affidavit, written the same day Allen was interviewed, that Allen admitted wearing a black or blue Carhartt jacket. In fact, Allen told investigators he did not know what he was wearing that day. Even if Allen did not argue this specific falsehood in his brief below, and that's just to remind you that on this issue, the state argued back and said, well, this wasn't one of his falsehoods that he even mentioned in his Frank's memo. So they're addressing that here by saying, even if Allen did not argue the specific falsehood in his briefing below, this court may consider it in response to the state's appellate argument that Liggett simply forgot. The common thread is plain. Liggett's affidavit forgot every fact that did not fit his theory that Bridge Guy was Allen. So that's like just a little way they're arguing this. They're saying, all right, don't consider it as one of the falsehoods, but consider it, okay, in opposition to the state saying, oh, just forgot, and look at these other things he just forgot. Because that I do think that the appellate court can do. So
yeah, I agree. And I want to have a veneer of reliability Defense Diaries t-shirt. A veneer of reliability. It's so beautifully written. Like those little nuggets right there. It's quality writing.
You tell me Michael had no comments on all that?
I don't know.
Maybe he left.
Where you at, Osbrook? Where you at? Show yourself, man.
Is anything I'm saying actually helpful?
I think it is.
I do too.
Okay, see, Blair's omitted descriptions were made with reckless disregard for the truth because they directly negated the warrant's core finding that Allen was Bridge Guy. When the state concedes that Liggett omitted parts of Blair's identification, excluding Allen or his vehicle, the state argues that Allen failed to show these omissions were made with the requisite intent to mislead or with reckless disregard for the truth. The state is wrong on both law and the facts. The state misreads State v. Allen as holding that intent to mislead cannot be inferred from omissions themselves. But that case rejected the proposition that any omission shows such intent, not that a material omission cannot support that inference. Settled Indiana law provides that omissions are made with reckless disregard for the truth when an officer withholds a fact in his ken that, quote, any reasonable person would have known that this was the kind of thing the judge would wish to know. And that comes from Query v. State. I said I wasn't going to cite him, but it's hard not to. So Blair's omitted descriptions were exactly that kind of fact. So Blair's descriptions directly undermine the affidavit's central conclusion that Allen, quote, is the individual on the bridge. Liggett swore under oath that he was able to, quote, corroborate information that Allen was at the trails at the same time Libby and Abby were, and that, quote, the individual in that picture on LG's phone matches the description of Richard M. Allen. But Liggett knew that Blair, the only witness who was on the bridge at the same time as the man, described someone who did not match Allen and a car that did not match his. So he withheld that contradictory evidence while including the portions of other witness accounts that supported his conclusion, which I'm not sure what those were, because everybody that they had as a witness describing this person gave a different description. This is one of the things I was slightly irritated. I'm like, wait, who are all these people describing Rick Allen? Because not one of them did.
Yes, and a lot of
And-
people are asking, like, what is meant by in his ken? So ken's like an old English word, meaning like in the range of what someone knows or perceives. So a fact in his ken, or a fact is like a fact he knew, a fact within his awareness.
Where was that first footy? Where was one? I didn't see it. It's at the end. Okay, so the footnote says that Wilson's description of the car at the CPS lot as a purple PT Cruiser SUV type vehicle is more consistent with Allen's black hatchback. What is this weird note thing, man? I can't even read the shit. Boop. Than Blair's description of the car that is not black with sharp angles. So
I think it just said Allie highlighted this or something.
it said that you had a note there. I mean, what Betsy Blair described was like a Mercury Comet, like an old muscle car, real sharp angles, from like the 60s. It looked nothing like a Ford Focus, obviously. So the selectivity was not neutral. Liggett included every description pointing towards Allen while suppressing those excluding him. Had Blair described someone who looked like Allen or his car, there is no doubt her description would have been front and center to the affidavit or in the affidavit. The state contends that Blair's descriptions are immaterial because the timeline is so tight that Allen had to be bridge guy, regardless of Blair's account. So, but that argument assumes its own conclusion.
He sure as fuck does.
Yeah, the tight timeline holds together only if Blair's account is set aside. And then we've got footnote 2. The state argued the omission of Blair's description was justified, not a mistake due to misunderstanding or a slight mischaracterization, and that is citing Daring v. State. Okay, so the state contends that Blair's descriptions are immaterial because the timeline is so tight that Allen had to be bridge guy regardless of Blair's account. But that argument assumes its own conclusion. The tight timeline holds together only if Blair's account is set aside. The fact that the only eyewitness who definitely saw the man on the bridge described him and the nearby car in ways inconsistent with Allen and his vehicle in precisely the type of information, or dude, I hate this orange.
I changed it.
Never use it again.
Going down, I
It's
changed
too hard
it.
for me to read. Is precisely the type of information a neutral magistrate would want to know before issuing a search warrant for someone's home.
All right, I'll do D, and I put a comment up there. I thought you might be interested in reading.
Oh, I did. I restarted a long time ago.
Okay, you
Thank
can
you.
take that off then.
Yes. Okay.
When did I start to change? Okay, right, it's coming up. All right, D. Without the falsehood And with the omissions restored, probable cause evaporates. The state's probable cause theory rested on 3 pillars: right place, right time, right clothes. The clothing connection. The clothing pillar falls first. Liggett tied Allen to Bridge Guy through clothing 11 times in the 4-page affidavit, twice falsely representing that Allen admitted wearing matching attire. In reality, Allen said he did not know what he was wearing that day. He could have worn a blue or black jacket, but also a hoodie or a sweatshirt. The blue or black jacket was the glue holding the state's timeline together. Strip away the false claim that Allen admitted wearing it, and the clothing connection dissolves. Boom. Clothing connection gone. I love how they do this. There's 3 things that tie him. Let's attack each of them. So 2 is the timeline. Blair's omitted descriptions of both the man on the bridge and the vehicle in the CPS lot directly contradict the state's timeline theory. Even the state acknowledges that, quote, the discrepancies between Blair's description and Allen's appearance might be significant to the existence of probable cause, citing to their brief. Yet the state offers no reasoned basis for setting Blair aside. Blair is not peripheral or unreliable. She is the only person who unquestionably saw the man on the bridge, and the ISP itself validated her account and sketch in a 2019 press release.
Strong
Liggett,
point.
yes, Liggett hid that validation from the judge. Allen also never, quote, placed himself on the bridge at the same approximate time that Blair saw Bridge Guy there. 2 days after the murders, Allen told investigators he was at the trails from approximately 1:30 to 3:30. So this is where my head explodes. My veins are popping out. I want to just strangle every defense attorney known to man. And I scream and I say to Bob, what in the fuck is going on? He did not say he was there from 1:30 to 3:30. So I reached out to Sleuthy and I said, am I insane? Do we have the actual thing? Because I had thought I had read it before. And she tells me I'm not insane. And she sent me the actual, words that were written.
Spoken by Rick Allen.
That are written down,
Yeah.
Which read, and I know what it is, but I'm going to read it anyway. I text it to you too.
See, this is the problem with the Doolin thing. Like the Doolin, we don't know what he heard anyway.
Right.
You know what I mean?
He wrote down.
It's
right. And so what he wrote down is Monday between maybe 1 and 3. So again, I've been screaming, if he's writing down between maybe 1 and 3, that screams someone who says, I don't know, I was there sometime between 1 and 3. This to and from that every fucking defense attorney is doing in this case makes me want to kill somebody. Makes my head explode.
Maybe send that to Stacy and Mark anonymously so they can an oral argument. Just throw that in there.
Right, because obviously when you say
huge difference. It's a range of time as opposed to a definitive window.
Right. They're
2 completely different things. I'm with you 1,000,000% on that. It's a huge distinction. Huge.
5 years later, he said it was around noon to 1:30, which I don't know about that one. Maybe he did use the words to, but it got purpled anyway. Similarly,
what does purple mean?
Purple means my head's exploding.
Oh, okay, that's good. Did you put a key somewhere so we know what the different colors mean?
No,
head exploding.
It's the only time purple is there. So
okay, all right.
And then I very soon stopped because again every word matters. So similarly, The harvest store video shows a car whose license plate and driver are both unidentified.
Unidentifiable.
Unidentifiable.
Can't be
It
identified.
can't be identified.
I mean, Yellow Jacket did a pretty good job of identifying that it's not a Focus. It's not Rick's car, with using the measurement of the wheel to the back of the vehicle. I mean, like, what she did was pretty amazing, frankly.
Well, I haven't seen that. I gotta
To
watch
me,
that.
what?
I haven't seen that. You didn't tell me about it.
Yellow, DM what you did, the pic to Allie so she can see it.
On what? What would I have to get on for DM?
Twitter, X, whatever.
All right. Well,
Or send it to me and I'll send it to her, whatever.
okay. So even if the car were Allen's,
Definitive. Let me put it that way.
Blair's testimony that the car in the CPS lot was not black and had sharp angles suggests Allen was more likely departing via Farmer's entrance, consistent with his 2017 statement to Dolan that he parked at the old Farm Bureau building. And then there's a footnote 3.
Bureau. Wow, I like the way you said that.
Bureau.
The Bureau.
Bureau. Bureau.
Yeah, the Bureau. There's plenty of folks out there that say Bureau.
Bureau.
Yeah.
Federal Bureau of Investigations.
Bureau.
All right. Although Allen did not believe he parked at the farmer's entrance, he was far from certain and trying to reconstruct his memory. They're still just ignoring the other place that he actually parked.
It's crazy. It's absolutely crazy. I mean, when you watch his interview, he's clear. He's like, I always drive through town and I come up through this little back entrance, this kind of road that leads right up to the place where you backed into that pole and made a hole in the car. Remember that place? I'll never forget that spot.
That's not his spot. He had some little spot underneath, and there was like a back road.
It was so there's the little bridge before you hit the Freedom Bridge. This is all on the other side of the highway.
Right.
So this isn't on the trail side at all. I mean, I was with there. Kathy walked me all the way down. She's like, okay, there's the road. Now they have large boulders so that you can't pull up from that road anymore. But back then it wasn't like that. Right. I mean, she's like, this is where we always park. This is where Rick was talking about. Because you drive right out of town, right up that road, and you're right there.
Yeah, it's crazy. It's crazy. That's the other thing they need for oral argument, that there's multiple places he could have parked. That's not the farmer's entrance and not something else and not whatever else you guys are all.
I thought he was definitive that he didn't park there because there's usually cars there, and there was a period of time when they didn't want people parking there and all kinds of shit that he was talking about in his interview.
For whatever reason, the defense now finds it helpful to say that he could have parked there and that he wasn't definitive, because they just still don't understand that there's a whole other place that he could have parked that he was describing. But all right, returning to the body. Stripped of the falsehoods and supplemented with the omissions, what remains is this. Allen took a walk on the trail in the early to mid-afternoon on the day of the murders and owned a jacket that could have been blue or black. That is not probable cause. This case is nothing like the Ware v. State case, which is something the state relied on, involving law enforcement who omitted an earlier eyewitness identification after excluding that alternative suspect through forensics. They had independent evidence supporting the warrant despite the omission. Here, there was no independent evidence linking Allen to the crime. Not one tip or witness identified Allen. As the Indiana Supreme Court has recognized, a neutral and detached magistrate, not a police officer, makes the determination of probable cause because officers are, quote, engaged in the often competitive enterprise of ferreting out crime.
Crime ferreting.
Quoting an Indiana case. I can't remember if it was Supreme Court or what, but that query case. Law enforcement cannot simply omit information that casts doubt on probable cause, citing back to the Ware case. All right, E.
Oh, all right. Oh my God, is that? Oh, I thought you used that purple shit again. E, the appropriate remedy for improper denial of a Franks hearing is reversal and remand. Michael's slightly irritated, maybe incredibly irritated with this particular thing because you can just remand it for a Franks. It doesn't have to be a reversal. So hopefully the argument won't be shot down because of that kind of distinction. Because what he's saying is you don't have to reverse it. You can just remand it down for the Franks hearing, do the Franks hearing, and then we roll from there. The state erroneously argues that there is no remedy for or harm caused by the trial court's failure to hold a Franks hearing. Courts have consistently reversed and remanded for a Franks hearing. So see People v. Zymentas.
So they cite two cases where that has occurred.
Right. And the state's own argument demonstrates the harm. The state contends that Allen failed to prove by a preponderance that Liggett's omissions and falsehoods were intentional or reckless. But that is precisely the showing a Franks hearing is designed to allow a defendant to make in person through confrontation with a full evidentiary development. So the state cannot simultaneously argue that Allen fell short of his evidentiary burden and that he was not entitled to the very proceeding where that burden is tested. A defendant is not required to make two proffers, one to secure a Franks hearing and another to demonstrate what he would have proven at the hearing. Franks and its progeny required no such thing.
I mean,
Ruling for the state, what?
It does a little bit. You've
What?
got to make that initial preliminary showing that you're entitled to a Franks hearing.
That's not what they said.
Correct. True.
What they said is the defendant is not required to make two proffers, one to secure a Franks hearing, which you were just speaking of, and another to demonstrate what he would have proven at the hearing.
Right.
Right. Okay.
Gotcha.
So, yeah. Ruling for the state would nullify the constitutional protection Franks established. Allen proffered statements from Blair Carbaugh, Allen, and his wife, and identified specifically how each contradicted the warrant affidavit. That proffer, at minimum, called the warrant's validity into serious question and entitled Allen to a hearing. Allowing the state's procedural argument to prevail would mean that any defendant whose Franks challenge is improperly denied before trial has no meaningful remedy after the conviction.
All right. So now we move on to section 2. The trial court erred by admitting Allen's confessions. Do you have any specific, like, just check the supers and see if any of them relate to the first issue that most of people are just being generous and saying that they love us and,
Yeah. I
Chabot
don't.
says Betsy Blair and the 4 girls saw Daniel Pearson pass it on.
Pass it on. Let's see. Nope. I don't think so.
Okay.
No.
All right. All right. And then we'll get to Sinbads when we get to everything that they excluded here. The trial court erred by excluding Allen's confessions. The state's brief answers a case Allen is not making. Again, the state's brief answers a case Allen is not making. It portrays this appeal as a challenge to every statement made by anyone in solitary, reframes 13 months of pretrial maximum security solitary as ordinary disciplinary segregation, and treats Allen's decomposition as incidental to, rather than the direct cause of, his confessions. That framing cannot be reconciled with the record. Allen entered IDOC with pre-existing major depressive disorder and was placed on day 1 in the most restrictive strip cell in the most restrictive unit of a maximum security prison. For more than a year, he was recorded, caged, and chained on every moment. He lost 40 pounds. He hit his head on the cell door until he had 2 black eyes. He ate his own feces. He was tased and involuntarily medicated with Haldol on 4 occasions. He was found, quote, very psychotic and formally declared, quote, gravely disabled. Meanwhile, the prosecutor waited 9 days to respond to an emergency transfer motion, mocked defense concerns as, quote, colorful and, quote, dramatic. On the same day, IDOC found Allen gravely disabled and used the delay to monitor real-time phone calls and collect medical records. Ultimately, the state reviewed thousands of hours of cell video and dispatched an ISP psychologist to consult with Dr. Walla. This is not passive receipt of volunteered statements. This is active cultivation of a pipeline of confessions from a man the state knew was losing his mind. Let's say it again. That is active cultivation of a pipeline of confessions from a man the state knew was losing his mind. The question on appeal is straightforward. May the state benefit from confessions obtained under these conditions? The answer remains no.
So the appellate issue is preserved because the trial court made that clear during trial. Under Rule 103B, once a court rules definitively on the record, a party need not renew an objection to preserve error for appeal. Immediately before the state called its first DOC witness, Allen's attorney requested a sidebar to discuss the mechanics of the confessions evidence and to, quote, make my objections now and incorporate everything that I argued in pretrial hearings.
All right,
During
so
this,
that is, sorry to chime in here, but that is significant. That is preserving the record. That is making an objection. That is incorporating all of your other stuff. So that's a huge deal here when it comes to these confessions.
all right, you be the court.
Okay.
Rosie, so I moved to incorporate those legal arguments as well.
Okay.
And then that way we're not making any objections.
I appreciate that.
Okay.
That way, because you've made a great record of all of those hearings, at all of those hearings. So I think we can, and I'll grant your motion to incorporate all of those
Okay.
into these proceedings.
Later, counsel renewed the objection to Dr. Wallace's testimony, quote, based on everything that I argued before. The court confirmed it and cautioned, quote, we don't have to beat a dead horse. By incorporating Allen's arguments and stating the court appreciated Allen's attorney's offer to avoid objecting to each of Allen's statements, the court issued a definitive ruling and acknowledged a continuing objection. Moreover, the court's admonishment to stop beating a dead horse or to stop beating dead horses only confirms the earlier ruling that additional objections are unnecessary. Allen did not need to renew his objections during testimony, v. Horn v. State. So defendant need not object where pretrial ruling states such as unnecessary. So the fact that counsel said no objection to individual exhibits after the court had thanked him for not objecting and cautioned against redundancy does not constitute waiver. In Halliburton v. State, counsel made no attempt to argue or object at trial. Here, counsel incorporated prior arguments, renewed objections twice, and received express judicial acknowledgement. Moreover, the purpose of the waiver doctrine is, quote, not to create a procedural trap. McGregor v. State. Defendant's failure to object to a final instruction did not constitute waiver, where he timely objected to the instructions as a preliminary. And that is exactly what the state's argument creates, a trap. When the court asks, do you object to an exhibit? An objection to the suppression issue would violate his assurance to the court that he would not object. If the attorney responds, no objection, He waives argument that he spent days making in a preliminary hearing. The state does not assert that Allen's no objection denied the court the opportunity to address this issue that was significantly litigated. Allen filed a motion to suppress with a memorandum and 18 exhibits, including depositions, cell videos, body cameras, and the IDOC reports. The state responded in kind. The hearing lasted over 10 hours and into the next day, and the court ruled. The purposes of the objection rule were more than met when Allen would have no strategy for wanting confessions. He worked so hard in excluding to be admitted. So courts should not apply waiver with unyielding rigidity when the trial court has been alerted to the issue.
And was that Vhorn? Because I've got something to say on one of these cases, and I don't remember which one that was. DRC?
Yeah, I think it was DRC.
Well, they also cited this Vhorn case. I'll just say, like,
Vhorn was cited
above. So, like in Halliburton, the lawyers kind of did nothing and sat on their hands. So there's a good distinction here that here, he asked to incorporate it. The court said that they'll incorporate it, but with Vhorn, which they only cite like with one parenthetical at the end of a paragraph, it's I think directly on point. Indiana Supreme Court is holding that a defendant need not object at trial where the trial court has indicated such is unnecessary, and they can highlight it, during their oral arguments, which, by the way, they've asked for. So hopefully they'll get. But the trial court here did exactly the same thing. I'll grant your motion to incorporate, combined with we don't need to beat a dead horse, is function like it's basically a Vhorn grade judicial direction to not keep objecting.
Right.
So I think that Vhorn is very, very strong here. The court issued a ruling, counsel complied, and now the state's trying to argue that compliance is waiver. And
they got to get to the merits on both of them. Like the shit was not waived. Just wasn't. Especially the confession stuff.
Yeah. Did you finish? And it's my turn, or did I interrupt?
Yeah, it's B.
Okay. B, the trial court erred by refusing to consider the IPAS material that undermine every argument the state makes. The IPAS materials are part of the record as a proffer. If the trial court erred by failing to consider them, this court, the appellate court, can correct the error by considering it on appeal. And they cite a different Allen case for the proposition that reviewing issues raised but not addressed by the trial court de novo, meaning like starting anew. So
you see how that orange highlighter sucks?
Yeah, I thought I switched to
really hard to read.
I'm done highlighting after this. This is it. That's the last highlight. To
Excellent.
Hold otherwise would deny Allen any remedy for the trial court's failure to consider relevant evidence. The IPAS orders findings that prolonged solitary of SMI, seriously mentally ill, inmates causes predictable deterioration with, quote, hallucinations, sleep disturbance, memory problems, anxiety, paranoia, depression, eating problems, or self-injury, cause the causation link the state says is missing. Prove IDOC's knowledge of the harm and refute the state's, quote, basic needs were met framing. The order finds that IDOC was deliberately indifferent to the mental health needs of those inmates with SMI, like Allen, by confining them in prolonged solitary. The state's argument that IPAS is irrelevant because the settlement resulting from the order may have expired misses the mark. It misses the mark. This is accurate. IDOC knew they had a duty to treat Allen's mental illness by moving him out of solitary because they had been successfully sued. There is no expiration on IDOC's knowledge or the district court's order. And that is what is important. It wasn't like the time the order wasn't in effect. It was the fact that they had knowledge. They knew that these were the harm that comes from prolonged solitary, especially with people with severe mental illness, period.
And before so I just want to explain to people, if you're wondering what IPASS means, what that acronym means. So in 2016, there was a settlement between the ACLU of Indiana and the Indiana Protection and Advocacy Services, also known as IPASS, and the Indiana Department of Correction, regarding improved mental health care for inmates. The agreement mandates, among other things, that seriously mentally ill prisoners are not housed in solitary confinement. Okay, so that's what it is. Now, Michael had texted me when we were talking about the brief earlier, since I don't know where he is, but it's worth noting. Okay, so there was one thing. So, and this is one of the omissions that he would have liked to have seen in it, and it's that they leave out the IPASS agreement was in effect until 4/22 of 23, well into the period when Rick was psychotic. Okay. So, I mean, that's probably worth noting. But whatever. All right. Did you make it to the end of it?
Oh, yes.
Oh, you did?
Wait, you're on C now, or you were just
Well, did you finish? Did
I
you finish
did.
that? Because I was
Yes.
looking. Okay. All right. So C, the state's prolonged confinement of Allen constituted coercion, even under the law of the state cites. Okay, so coercive state action is not limited to police interrogations. This gets to the heart of it. This is what I was arguing about for years. You know, that like people, when they think of interrogations, they think of being in the room for 12, 13 hours. They're not allowing you to sleep. They're coming at you nonstop or in waves. They're techniquing you. They're not giving you food. They're not giving you water. They got the light shining and all that shit, right? This wasn't that. This wasn't that. It was very, very different. It was far more nefarious because at least there, you know what they're doing. It's open and obvious. This was different. So the state argues that none of the usual hallmarks of police coercion are present because there was no traditional interrogation. But Colorado v. Conley, 1986 case, holds that coercive police activity is a necessary predicate, not that coercion is limited to the interrogation room. Courts have recognized as much. Townsend v. Sane, exploitation can occur in other ways through administration of a sedative. USA v. DF, that's a Seventh Circuit, our circuit. A mental health facility's reward system rendered to juveniles' confessions involuntary without traditional interrogation. And that's what I always said. What I was saying is all it took by the time Rick Allen's eating his own shit and smashing his face against the wall, that all they had to do and cutting him off, not from a tablet communication with his wife, but laying eyes on the woman who is his entire support system and has been for 35 years. When they shut him off from that, and they compound it with everything else. No blanket, laying on the floor, eating his own shit. Like I'm talking like war crime shit is what he was in. War crime shit. Like make under surveillance 24/7. You know, he couldn't turn the lights off. They're talking about he could dim it. It was so cruel. But all they had to do is this. It's this reward system where all one guard had to say is, Rick, you want to see your wife? Just say you did it. It's that simple. That's all it would take. They don't have to beat it out of him. They had already done that psychologically. That's all they had to do is say, hey, man, you want this shit to be over? You want to get moved out of this hellhole? Just tell us you did it. Right. That's it. So Townsend v. Henderson. Conditions of solitary confinement themselves, quote, conveyed the implied threat of further punishment. USA v. Karaki. Months in solitary, quote, by itself suffice to render confessions involuntary. So as law enforcement officers become more responsible and the methods used to extract confessions more sophisticated, the court's duty to enforce federal constitutional protections continues, and that's Spano. So the unprecedented nature of this case does not mean the statements were voluntary. The state failed to cite any case where it was permitted to capitalize off the psychosis they created.
2 under the same heading here. The condition of Allen's confinement were coercive. A, the state ignores Allen's mental illness when arguing no coercion. There is no doubt that solitary confinement is a hallmark of coercion, citing to U.S. Supreme Court case Chambers v. Florida from 1940 and Brooks v. Florida from 1967. What it does to the mind is not contested science. It is a recognized method of breaking down human will. Another U.S. Supreme Court, Davis v. Ayala from 2015, and they cite to Justice Kennedy's concurring opinion, solitary, quote, can bring a person to the edge of madness, perhaps to madness itself. They also cite a Third Circuit case from 2017, recognizing scientific connection between prolonged solitary and negative psychological effects. And they cite a Pennsylvania Supreme Court case, unless that's Superior. 11 days of solitary rendered a confession involuntary. Conditions would, quote, destroy the willpower of almost any human being. The state's contrary cases each involve rational defendants. In Rivera, the defendant had counsel present and was not mentally ill. In Giles, the court found the defendant, quote, a rational person, able to consider his options and make intelligent, rational choices. That's a 7th Circuit 2019 case. Here, Allen was smearing feces on himself, speaking to people who weren't there, and being involuntarily medicated on the very days he confessed. In Kiendra, the defendant spent 30 days in solitary, 1/13 as long as Allen, and was not mentally ill. And that's a First Circuit 1981 case. These cases establish a floor that Allen's case vastly exceeds. And I'll just say I did a little bit more research, and I think I did this on our last live that you and I were on, like before I was with Andrea, I think, that, there's a strong argument from all of this that Allen's 13-month solitary confinement violated evolving constitutional standards that recognize prolonged isolation as inherently coercive and degrading to human dignity. Recent Federal Circuit authority establishes that even 3 months of solitary confinement in harsh conditions creates a protected liberty interest requiring due process protections, and that longer terms of solitary confinement alone suffice to show constitutional violations. The conditions Allen endured, constant video monitoring, suicide companions documenting statements 24/7, the systematic collection of psychosis-induced confessions represents the type of sophisticated law enforcement methods that the courts must scrutinize under evolving constitutional protections. The state's cultivation of a confession pipeline from a severely mentally ill detainee violates those fundamental principles and human decency of due process. There is a 7th Circuit 2025 case, Jackson versus Anastasio. Now, it's not exactly on point, but it discusses all of this. It says that the decision provides prospective guidance that 3 months in appalling conditions of solitary confinement creates a protected liberty interest, and moving forward, such short terms combined with disgusting conditions will suffice to show a protected liberty requiring procedural protections, and as will longer terms of solitary confinement alone. So there, the court granted qualified immunity, and they do that when the law is not clearly established at the time. And that decision that in the Seventh Circuit, it doesn't create binding precedent for a constitutional violation, but it's still very persuasive. But here, where they didn't have qualified immunity because it wasn't clearly established law, that's where the IPAS and all that stuff come into play, because they were on alert that whether or not it's clearly defined law, there was law that they were aware of that needed to be followed. So here there is a concurring opinions footnote that that says that solitary confinement can degrade human dignity and be as clinically distressing as physical torture. So that's in a footnote in a 2025 Seventh Circuit case. There was also United States v. West. It was a Seventh Circuit 2015 case where expert testimony, and this I'm just mentioning it now, and it obviously becomes relevant as we get to that, but that expert testimony explaining a defendant's mental disabilities and how they influenced responses. Here it was to police questioning, but same thing, how it influenced his thinking and speaking, whatever, is highly relevant to a jury's consideration of the defendant's personal characteristics and confession reliability. And such testimony should be admitted when it bears on the trustworthiness of statements. Again, there it was statements to police. The court held that such testimony is admissible for assessing confessions reliability when mental capacity issues affect the defendant's responses to questioning or what the defendant is saying. So, and again, that's Seventh Circuit, but there's also, and I didn't see them cite this, State v. Banks, Indiana 2014 case that found a confession involuntary where it was obtained while the defendant was involuntarily medicated for schizoaffective disorder in restraints and housed in a psychiatric ward, displaying poor insight and judgment. So Allen's case presents even more extreme circumstances with 13 months of isolation, causing documented psychosis and involuntary medication. So I think that those arguments about the evolving constitutional standard tied to what they already knew and the IPAS stuff is powerful.
I agree heavily.
All right, so I think you're at B.
Yep. The state's slippery slope argument fails because Allen's confinement was unprecedentedly harsh. Allen's confinement was unprecedented. So Allen was the only pretrial detainee in maximum security solitary in recent history. Pretrial detainees with serious mental illness are housed in mental health treatment units. Allen was constantly video monitored, even when not suicidal and when moved out of the cell. Suicide companions were at his cell door 24/7, documenting his statements even when he was not suicidal. Pursuant to IDOC's own policies, any other inmate who deteriorated like Allen would have been moved to a mental health unit. Allen was kept in solitary 13 times longer than the 30-day limit to which IDOC agreed in IPAS. Allen's harm was both mental and physical. These are not predictable consequences, or these are not the predictable consequences of, quote, disciplinary segregation. They're the predictable psychological pain of prolonged solitary on an SMI detainee. They're the very effects IDOC's 30-day policy exists to prevent. And they are more severe in medical and psychological damage than the conditions described in Brooks v. Florida and Donnell v. Myers, because they lasted not 14 days, but 13 months. Allen does not argue that every statement by every restricted housing inmate must be suppressed. He argues that these conditions imposed on him with his mental health profile over this duration, while the prosecutor actively cultivated confessions, overbore his will. That is precisely the totality of the circumstances required. And that's Schneckloth v. Bustamante.
And before I go on to D, Yellow Jacket says there's a reason he confessed to prison guards, prison warden, and prison psych, and not to prosecutors, judges, or cops. Great point. All right. D. The state failed to prove that Allen's confessions were voluntary. The state applies the wrong test and inverts the burden of proof. The state frames voluntariness as requiring, quote, outrageous or barbaric conditions, citing the state v. McVeigh. Arizona's formulation is not binding. Connolly asks whether the state engaged in coercive activity, citing to a U.S. Supreme Court case. So Richmond asks whether the defendant's will was overborne under the totality of the circumstances, a test in which mental illness plays a substantial role. The state also impermissibly shifts the burden by characterizing this as, quote, a sufficiency matter. The state bears the burden, preponderance federally, beyond a reasonable doubt under the Indiana Constitution. Voluntariness is a legal question reviewed de novo. Courts must consider even uncontradicted evidence unfavorable to the verdict, citing an Indiana case from 2013. The question is not whether Allen can prove coercion, it is whether the state can prove the statements were voluntary. And we made a huge point of this in our, I think it was something that Michael had to concede because the state's just wrong.
Yeah.
As he put on his, I want to call it not a white hat. I hate that that's the white hat. But while he was acting as the state in our arguments that we did when we had Andrea on.
2, considering the proper test with the proper burden, the state failed to prove Allen's will was not overborne by his confinement. The state argues that the conditions of confinement did not cause the confessions because the conditions did not, quote, become more oppressive before the confessions began. Connolly only requires that the state's conduct be causally related to the confessions. In Townsend v. Henderson, the conditions did not escalate at the moment of confession, yet the, quote, implied threat of further punishment, end quote, conveyed by solitary itself vitiated free choice. Moreover, the state's argument ignores the clear connection between the duration of solitary and psychosis established in the IPAS litigation and IDOC policies limiting confinement of SMI inmates to 30 days. Dr. Westcott opined that Allen's psychosis was caused by prolonged solitary acting on his pre-existing illness. Even Dr. Walla, the state's own witness, agreed that it was, quote, reasonable to believe Allen's confinement caused his psychosis.
A, Allen's confessions correspond with his psychosis. The state argument that Allen was mentally stable until April 13th, 2023 is belied by the record. In March, Allen told Dr. Walla he was struggling mentally. By March 30th, he was paranoid and evasive. By April 4th, Dr. Walla described his mental health as, quote, extremely poor, critical, and deteriorating. By April 12th, he was eating his feces and banging his head on the walls. Allen's attorneys also noted his steep decline beginning March 24th, 2023 in their emergency motion. They included photographs taken before he was arrested and on April 3rd, the day he started confessing. And there's some pictures there for everyone to see how deteriorated he is. Also, at 3:12 a.m. on that same day, April 3rd, Allen called his father, quote, I don't know how much longer I'm going to be lucid. He described being, quote, mentally tortured for the last 5.5, 6 months and feared he was being poisoned. A few hours later, Allen called confessing to his wife. His words were not, I did it, but I think I did it. And yet, in a third call that morning, he could not remember confessing and was afraid he was, quote, losing his mind. He later claimed to have shot the victims, a claim contradicted by medical evidence. A false memory begins with a belief, and that prolonged isolation is a known cause of such beliefs, quoting to the record. Likewise, Allen's psychosis did not magically end on May 3rd, right before he gives the most detailed confession to Dr. Walla. He was involuntarily injected with Haldol 3 times in May and June. And they cite to the record and say Walla admitted, quote, if somebody was just faking something, you wouldn't need to tranquilize them to get them to stop. On June 11th, he believed he was in hell. On June 20th, he was catatonic. Allen's statements expressing guilt correspond with his psychosis, a time he does not even remember. And that's got a footnote 4. The state cites one exception, that in February 2024, Allen apologized for killing the girls. However, he was curled in a fetal position, talking to himself, still on antipsychotic medication, and fluctuating between calm and hysterical. It takes time to heal from the damage the solitary confinement caused. Yes, obviously, idiot state. After 5.5 months of solitary, Allen lost touch with reality, questioning not only whether he was innocent or guilty, but whether he was dead or alive.
B, the state's alternative cause theories are speculation. The state's theories that Allen's discovery and religious conversion independently caused his confessions are speculative and are no different than arguing that a person who confessed after being beaten might have confessed anyway because he was guilty. Dr. Walla admitted that Allen's decline started before his receipt of discovery and that she had never seen Allen's discovery, despite hypothesizing in a clinical note that it possibly triggered his breakdown. Even if discovery contributed to Allen's decompensation, it does not sever the state's causal contribution. A pretrial detainee does not respond to receiving legal papers by eating feces, ripping mail, and writing a confession under a cell door. Allen responded that way because 13 months of solitary. Did you read this? Where was 4?
Yes, I read it.
Okay. Allen responded that way because of 13 months of solitary had stripped him of all reserve. If anything, the discovery provided a basis for his delusions.
3, Allen's state constitutional claim is meritorious. And there's a long footnote. Allen stands on his appellate brief regarding the other Indiana constitutional claims, although the due process of law provision has been applied in civil cases. Allen's case is unique. And they cite to an Indiana case there. Allen was not seeking due course of law for the deprivation of liberty. He was seeking a hearing for the, quote, injuries from IDOC's pretrial solitary. Also, the second provision of Section 12, quote, aimed at the judiciary, not the legislature, has applied to criminal cases, citing to 2008 Indiana case. When considered with Article 1, Section 15, and that's to the Indiana Constitution, there must be some due process to protect against unnecessary rigor when arrested and confined in jail. The state concedes that Article 1, Section 14 requires the same, quote, coercive state action that Article 1, Section 14 requires the same coercive state action predicate as federal due process by pressing the very argument that the Court of Appeals already rejected in State v. Banks. And in that case, they rejected the state's reading of a Jabu case, and so I guess not important. In Banks, police interviewed a heavily medicated, mentally ill detainee who later did not even remember confessing. Here, police collected confessions of a heavily medicated, mentally ill Allen, who later did not even remember confessing. Just as law enforcement caused Banks' confessions by interviewing him when they should not have, the state here caused Allen's confessions through prolonged solitary confinement. Allen's confessions were not a product of rational intellect, but rather a psychosis caused by the state's indifference to his mental health. The state also ignores Indiana's distinctive, heightened burden of beyond a reasonable doubt. Even if coercive state action were required, keeping Allen in a maximum security solitary past the predictable onset of psychosis, declining transfer against its own policy, monitoring, collecting his statements, opposing his transfer motion, establishes it. And I'll just read this. The error was not harmless. At trial, the state called 12 witnesses and introduced 17 exhibits involving over 30 conversations. During closing, confessions, involving over 30 confessions. During closing, the prosecutor walked the jury through 18 of those and twice replayed Allen's phone calls. Of course, because they didn't have to use the bookend calls, of course, In rebuttal, the prosecution argued that Allen knew a fact only the killer would know. The state's argument that the confessions were harmless does not survive scrutiny. I don't even think you can say it with a straight face. I just don't even think you can say it with a straight face. Bullshit.
All right, 3, the trial court denied Allen his right to present a complete defense, to explain the scene, and to impeach the investigation. So a criminal defendant has a federal and state constitutional right to present a complete defense. Evidentiary rules that exclude critical defense evidence on grounds disconnected from the rule's purpose violate that right. Holmes. The trial court's rulings on 7 categories of defense evidence violated that right and require reversal, and the state's contrary arguments are unpersuasive. Go with A.
All right. So A, the trial court committed reversible error by excluding Blair's sketch of Bridge Guy. No eyewitness identified Allen as Bridge Guy at trial. To prove Allen was Bridge Guy, the state rested its case on a compressed timeline where every witness needed to have seen the same person. Blair did not see Allen. Her sketch proves it. And I'll do one, but I wanted to come to Sinbad's. Oh, no, not yet. Sorry. Okay. I thought we had a comment that went right to that. And well, Sinbad did make a comment that goes to the earlier thing about solitary. He said Allen wasn't in solitary. He had inmate companions, could do recreation, unlimited family visits / calls,
Wrong.
meet counsel, use commissary, and a tablet.
Wrong.
I mean, the inmate companions weren't supposed to.
The inmate companions were not allowed to speak with him.
Right.
They were stationed out there to write down every word that he said. He was cut off from all family visits. Kathy Allen could not go visit him. Sinbad, you sound like a psychopath.
Hey, don't attack Sinbad. He's
No, you know
allowed
what?
to have
Like,
his
you're
opinion.
just not you're not being intellectually honest. Like, if you think that it's okay for somebody who's presumed innocent in this country to be held under those conditions, I don't know, man. Like, I just don't know where your head's at. It's offensive. You're
Well,
an
Dated
offensive
for Justice
person.
said it well.
Huh?
She said, how fucking evil do you have to be to do this to a person? These people need to be held accountable for their actions towards Richard and his family.
I'd like to send that person their $5 back, because
No, stop.
What do you mean stop?
Well,
Like,
you
enough is it? Like, anybody who's okay with any American citizen being treated this way is full of shit. This isn't a game.
No, I agree. Obviously, I agree.
Well, I don't know what you're like. Don't take this person's like position.
we're
Like,
just
I don't feel bad for this person.
we're big on
I wish I
allowing
could see
people to
this
speak their
person in real
mind.
life, and then we could debate it.
We're
face
big
to
on
face.
allowing people to speak their mind. So I'm just trying to.
And I'm speaking mine.
All right. Okay, so one, the issue is preserved. The state argues waiver because Allen made no offer of proof at trial. That argument rests on abrogated case law. Since 2014, Evidence Rule 103B has provided that once a court rules definitively on the record, a party need not renew an objection or make an offer of proof to preserve the error for appeal. That is what occurred here. The court held a hearing where the parties argued extensively whether Blair's sketch was admissible and issued a definitive written ruling, quote, prohibiting the defense from using the composite sketches in the trial of this cause. There was no waiver. Two, the sketch was relevant and not unfairly prejudicial. The state argues that the sketch was irrelevant because Blair never identified Allen as bridge guy. That's where you want to just strangle them. The state has the logic backwards. The sketch is relevant precisely because it proves Blair never saw Allen at all. She saw this man. Picture of our curly-haired young friend.
Poofy hair.
Poofy and curly-haired young friend. Just 3 days after the murders, Blair described the man she saw on the bridge platform as white, approximately 20 years old, medium build, with brown curly hair. At the time of the murders, Allen was 44 years old with a closely cropped hair he had kept since 1989. The sketch can serve as substantive evidence of innocence to prove someone else committed the crime, citing to an Indiana case. Blair's sketch does exactly that. The state claims the sketch was unfairly prejudicial because the jury might use it to exclude Allen as bridge guy. That is not unfair prejudice. That is the sketch's probative value. And, you have to laugh when the state makes an argument like that, well, it's unfairly prejudicial because it might exclude him. It's the same thing that the state's always arguing in reverse. Well, all evidence is prejudicial to the defendant. All the evidence the state wants to put in evidence is prejudicial to the defendant. And the court and the law tracks that. Well, all evidence against the defendant is prejudicial. So we have to do the balancing test. And now the state's trying to say, wait, that it's prejudicial because it hurts our case. Yeah, all this defense evidence that hurts your case is prejudicial in your mind. It still requires exclusion. I mean, admission when it is relevant and pertinent and its probative value outweighs your prejudice of saying, wait a minute, your evidence is proving this guy didn't do it. We can't have that. No. Bullshit. Okay, returning to the body. The state claims the sketch was unfairly prejudicial because, I just said that. Prejudice is not unfair simply because it undermines a party's theory of the case. That's exactly what I was just ranting about. Said in one sentence instead of what I did. So the state made Blair. Thanks, babe. Yeah. The state made Blair a cornerstone of its identification theory, telling the jury in closing that, quote, every witness is adamant the person they saw was bridge guy, with no doubt in their minds, and that Allen was on the bridge exactly where Blair saw bridge guy. How is that not saying that Blair saw bridge guy? I mean, Allen. How is that not saying that Blair saw Allen? You said it, state. You said it. Blair saw Allen. It's like, how? How can they make these arguments with a straight face? Having built its case. Sorry, I want to make sure I didn't skip a sentence. Having built its case on Blair's observations, the state cannot simultaneously claim that what Blair observed, captured in a sketch she rated 10 out of 10 for accuracy and declared the reliable face of bridge guy until Allen's arrest, was too unreliable for a jury to see. The state also argues the sketch was cumulative because Allen elicited Blair's verbal description on cross-examination. A syllogism is not a story. A syllogism? Please, babe.
Yeah, that's it.
What does it mean?
I don't know, dude.
Okay, sorry. He's our wordsmith, and so,
Yeah, typically.
a syllogism is not a story.
I'll look
Blair's
it up.
Blair's description, broken into fragments by questions from lawyers, is no substitute for the sketch. The sketch's persuasive force.
It's a
Only
form of deductive reasoning where a specific conclusion is inferred from two assumed premises,
and that is
a
exactly what.
major premise and a minor premise.
Yes, that. All right. So, no, for real though.
Yeah.
Blair's description, broken into fragments by questions from lawyers, is no substitute for the sketch's persuasive force. Only by viewing the complete image, the full face Blair drew 3 days after the murders, could the jury appreciate Allen's claim of innocence. And they quote to a United States Supreme Court case in 1997 for the proposition, quote, the persuasive power of the concrete and particular is often essential to the capacity of jurors to satisfy the obligation that the law places on them. Moreover, the sketch carried probative force beyond the identification question. For 2 years, law enforcement circulated Carball's sketch without an arrest. In April 2019, ISP released Blair's sketch, declared it the face of Bridge Guy, and announced Blair and Carball had not seen the same person. After Allen's arrest, the state reversed course. I mean, of course it did. Reverse. The sketch placed before the jury alongside that reversal would have told the story of an investigation that changed its theory when it became convenient. A story Blair's verbal testimony alone could not tell. Here.
Could never tell.
Could never tell. Sorry, that was so much better.
Yeah.
A story Blair's verbal testimony alone could never tell. I'm going to finish the sketch and you'll do the next.
Okay.
Topic. Okay. 3, the sketch was not hearsay, and if it was admissible. A composite sketch is a visual depiction, not a statement within the meaning of Rule 801A. It depicts rather than asserts. When courts across the country have encountered this question, they agree. The state does not dispute this and confines itself to arguing waiver, but as shown above, the issue was preserved. Even if treated as a statement, the sketch is admissible on 2 independent grounds. First, Rule 801D1C excludes from hearsay a prior identification, quote, of a person made after perceiving that person where the declarant testifies and is subject to cross-examination. The rule applies to identifications of, quote, a person. The drafters did not limit it to identifications of the defendant. The state offers no authority to the contrary. Second, and again, that whole argument that they're making, she didn't identify Richard Allen. She identified Bridge Guy, is the stupidest thing I've ever heard, because you, state, then made abundantly clear that the Bridge Guy she identified, the very man she identified, is this guy standing right in front of you. So she did identify Allen through you. You, the state, identified the person she drew as Allen. So go F yourself, period. Second, the sketch is an adoptive assertion under Rule 801, an adoptive admission under Rule 801D2B. The state, through the ISP, manifested adoption when it publicly released Blair's sketch in April 2019, declared it the face of Bridge Guy, and announced Blair and Carball saw different men. The state cannot formally adopt the sketch as authoritative before Allen's arrest and then bar its use at trial. B, the court committed reversible error when it excluded Perlmutter's, okay, so this is you, explanation of Bridge Guy's murder scene. But before we get there, one of the things that's...
I mean, can you imagine had they been able to show that sketch to the jury?
Yeah, I mean, it's as strong as they're making it sound, as strong as the state saying that would completely destroy our case here.
That's the guy they're saying is Richard Allen.
Right. So here is, and it's very short, and I'm going to share it. What happened during Carball's sketch. Okay, people, let's just see about this.
I'm going to grab a drink real quick.
Okay, he's going to forget this. All right, I don't know if I can make it any bigger. Yeah, I can. Well, let me hit play first, because.
Have you seen the picture in the news? I mean, you've had to see that.
I have. I also try but I try really hard also not to look at it too much because I saw him afterwards and I just remember blood.
Okay.
And I don't want to I'm trying to describe what I remember seeing.
Well, in previous situations I've been involved in, I'm sometimes hesitant about having the photo around because you couldn't tell that that's the actual person. Or then you'd be like, oh, wait a minute, you're showing a picture of somebody, but they know that's the guy. If that picture is sitting right here with us, do you think it would help you?
It might.
Because we can cheat.
He says they know that's the guy, and now he's saying we can cheat. So here we go.
I do this all the time. Like if there's surveillance photos from the bank or stuff like that, we can cheat. If you want to bring that in?
Yeah, because it might help me because
it's definitely putting it in context. So we don't have to make this hard. We can cheat.
No.
Let me go get it.
Yeah.
Oh, we can what now? Yeah, sure. Bring the picture in. I'll make it match. Sure. Okay. I mean, seriously?
It's crazy. It's crazy. I think it was Baldwin who crossed him too. The compiler.
I remember. I thought when I was there during a pretrial that came out, or like without the jury.
No, this was. He testified on cross that, or it was Carball. Carball was on the stand, and he got her to admit that she had seen the video, and that's what she was basing her, what she ended up telling we saw it right there. I mean, the whole thing is just insane. It's just not how, if you have a strong case, this isn't the kind of shit you pull. Right. If you have actual evidence against somebody that they've done something like this isn't the shit you pull. Like people making weird excuses for keeping a person who's presumed innocent in solitary for 13 months, like this bizarre thing. Oh, well, they would have been killed in Gen Pop. That's not what this was about. This was absolute isolation. This bullshit that he got to go talk to Walla is ridiculous.
Like he's in a box or something, wasn't he?
Like in a 3x3 cage.
Yeah.
Like Hannibal Lecter.
And Petty,
anybody who's okay with that kind of treatment of American citizens who are presumed innocent, you need to get the fuck out of this country. That is not going to ever be okay.
And Petty Please with sugar on top says the only reason Rick was, quote, protected from himself was they wanted their dog and pony show with a man they had broken mentally, betting he wouldn't fight. And thank you for that.
All right. So B, the trial court committed reversible error when it excluded Perlmutter's exculpatory explanation of Bridge Guy's murder scene. So Perlmutter holds which, by the way, we had Perlmutter on our show. It's in our library of Richard Allen videos, which are, I think, over 200. We have a lot of Allen coverage here. Nobody has even anything close to what we have on here.
Yeah. Started before everybody.
Yeah. We were the first ones to do it. So Perlmutter holds a federal subject matter expert designation from the U.S. government in ritualistic crime and has consulted with the FBI, DEA, and Department of Homeland Security. She directs the Symbol Intelligence Group, is an adjunct in a forensic medicine program at the Philadelphia College of Osteopathic Medicine, and has authored textbooks on ritualistic homicide. She has worked on dozens of ritual homicide cases and hundreds of ritualistic crimes, primarily for the prosecution. The state does not now argue she was unqualified. Its argument is exclusion under Rule 403.
Which would be it's more prejudicial than probative. Oh, no, not relevant.
So the foundation for Perlmutter's testimony was not speculative. It was the state's own investigation. The case the state relies upon, which is Pelley and Lashbrook, and their progeny, share a common premise: a defendant approaching the court with an alternative theory the prosecution never considered, supported only by the defendant's own speculation. That's Pelley. And hearsay statements about a Florida bank connection with no investigative support. That's Lashbrook. So a single ambiguous statement that the victim was, quote, was gonna die. The concerns animating those cases, jury confusion from unmoored alternative theories, is absent here. The ritual killing theory was not Allen's invention. It was law enforcement's own theory, developed from the first day at the scene, pursued for years, and supported by multiple independent sources. The foundation for Perlmutter's testimony is not a defense attorney's theory. It is 5 years of law enforcement investigation, FBI consultation, and academic analysis, all pointing in the same direction. What changed was not the evidence. What changed was the arrest. When Allen was charged, the state abandoned the theory, reversed its position on the Blair and Carbaugh sketches, and recharacterized the investigation as complete, and moved to exclude the evidence it had spent years developing. That reversal is not a neutral evidentiary decision. It is confirmation bias made visible. Law enforcement finding a more convenient suspect and retrofitting the evidence to fit him, discarding what pointed elsewhere. The jury was entitled to see that pivot. The trial court's rulings ensured it never did.
That's powerful.
It's powerful. The asymmetry doctrine required Perlmutter's admission, and the state fails to engage with it. The state called expert witnesses to interpret the crime scene's unusual features in an inculpatory direction. Allen was denied an expert to interpret the same features in an exculpatory direction. Indiana law has long held that the state may not use evidentiary rules as both a sword and a shield, presenting its version of contested evidence to the jury while blocking the defense from offering a contrary explanation for the same facts. The murder scene demanded an explanation that the state's theory could not provide. Sticks were deliberately arranged on both girls' bodies in configurations that covered no more than 3% of their surfaces. Far too little to conceal anything, serving no practical purpose a brutal opportunistic murder would require. Liberty German's 200-pound body was dragged several yards after death and positioned in a V formation. The girls were treated differently from each other in ways that suggest intentionality rather than impulse. The scene, taken as a whole, reflected a purposefulness, a deliberate, almost ceremonial quality that the state never explained and that sits uneasily beside its theory of a middle-aged pharmacy technician with no connection to the victims, no motive, and no history of violence, committing a spontaneous public murder before walking home. The state argues that Perlmutter's evidence was irrelevant because, quote, motive was not a significant factor in the proof of guilt. Allen never claimed motive was important to the state's case, but motive was critical to Allen's claim of innocence because the scene suggests a motive inconsistent with Allen's guilt. Trial court wrongly in State v. McElrath, trial court wrongly excluded a map that indicated an alternate murder plan inconsistent with the murder plan the defendant could have been involved in. A court cannot prohibit a defendant from offering evidence of an alternative motive because the state failed to present evidence of the defendant's motive. Although the state can open the door to otherwise irrelevant evidence, it cannot close the door to otherwise relevant evidence. Any challenges to the weight of pro-mutter's testimony are arguments for cross-examination, not grounds for exclusion.
Very powerful.
Yeah.
All right. C. The trial court denied Allen his right to show the state's investigation into Bridge Guy's identity was incomplete, overlooked plausible leads, and mishandled evidence. The state claims Allen failed to establish a nexus between the third-party evidence and the crime. The record refutes that claim across 5 independent connections. Nexus to the victim, AW, was secretly meeting with LH, the son of Brad Holder, the leader of the pagan group conducting rituals in Delphi every weekend. That is a direct personal connection between a named suspect and one of the murdered girls, established through law enforcement's own investigation, not the defense's speculation. And that connection became more significant, not less, as Holder's account of his relationship with AW evolved 3 times over 7 years. Nexus to the crime scene. Holder had a bind rune tattoo that was nearly identical to the stick arrangement on AW's body. Oh, brief addendum 4, sorry. Before those details were public, Holder was posting pictures depicting dead girls with sticks placed over their bodies. Westfall told law enforcement he knew the woods near the murder scene very well. Who is the he in that? Westfall or Holder?
Wait, what do you mean? It says Westfall told law enforcement he knew the woods near the murder scene very well. I think he's talking about himself.
Right, but aren't we only talking about, didn't they only raise 2 people? Who were the 2 people again?
What do you mean?
Holder's one of them in the
Well, yeah,
appeal.
obviously Holder's one of them.
Right. Maybe Westfall's. We'll see. We'll
Maybe, yeah, I don't know.
Nexus to the murder weapons caliber. Holder owned a .40 caliber Smith & Wesson, the same caliber as the cartridge found between the bodies. Law enforcement never collected or tested it. The state's firearms case rests on the proposition that only Allen's gun could have produced the scene cartridge, a proposition meaningfully undermined by the existence of an uncollected .40 caliber firearm. Nexus through law enforcement's own conclusions.
Wait, did they bring up Elvis? I don't, did they? All eyes? I don't think so.
No, that's been one of the things I've been screaming about. And then Sinbad said that Allen's defense team didn't seriously try to introduce evidence on Keegan Kline or Ron Logan. They could have shown a nexus to both as third-party culprits.
Yes, they did. Again, wrong. The 3 days of hearings, the only 2 people they brought up at the 3 days of hearings that were held with regard to the state's motion after Gull said, hey, state, you may want to file a motion to bar the third-party culprit defense because McClellan hadn't done it. And those were really the only 2 people they got deep into, were both of those 2 people. So, and she denied it. She said there was no nexus.
All right.
But dude, I mean, like Sinbad, just get right on the facts.
Well, I
You know
mean,
what
at
I
least
mean?
he's saying that they could have proved it.
But like the things that they're putting in chat are just blatantly wrong.
Right. All right. Nexus through law enforcement's own conclusions. The Carroll County Sheriff connected the sticks to pagan rituals immediately. Multiple officers concluded the scene was too complex for one person. The FBI, BAU, declined to exclude ritual killings. A Purdue professor confirmed the stick markings were consistent with Norse runic symbolism. These are the state's own pre-arrest conclusions, a nexus that law enforcement itself found compelling enough to pursue cannot be dismissed as insufficient when the defendant adopts it. Nexus through Holder's own admissions. It's italicized. Nexus through Holder's own admissions. In 2018, Holder told his wife that, quote, Patrick killed A.W. with, quote, others, and warned her that, quote, if I talk, that they will kill me. The statement is admissible as circumstantial evidence of Holder's own consciousness of guilt. A person without guilty knowledge has no reason to threaten his wife into silence about a crime he sincerely believes someone else committed. And the statement itself is joiner nexus evidence, and that's citing to a case, a joiner case. A named alternative suspect identifying another named alternative suspect as the killer makes it less probable that Allen committed the crime. And that would be like any evidence is admissible if it makes it less likely that the defendant committed a crime. So that's why they're talking about that. The state's nexus argument effectively requires forensic placement at the scene, DNA or physical evidence directly linking Holder or Westfall, I guess that was the two, to the murders. That is not the Joyner standard. Joyner required reversal based on motive, opportunity, conduct, and a forensic hair match. Allen's evidence, victim connection, crime scene imagery, same caliber firearm, direct familiarity with the murder location, law enforcement's own pre-arrest conclusions, and Holder's post hoc admission is a stronger multi-factor package than what Joyner found sufficient. Lashbrook distinguished Joyner on its face. It did not establish DNA as a universal prerequisite for third-party evidence in every case. The state's claim that police, quote, investigated and never connected Holder and Westfall to the crimes is not a response to Allen's argument. It is a restatement of the problem. The right to challenge the investigation's thoroughness would be meaningless if the investigation's own conclusions could insulate it from challenge, citing Kiles, a U.S. Supreme Court, and Sager, a Ninth Circuit case. Cleared in this investigation did not mean investigators looked and found nothing. It meant they accepted an unverified badge swipe without watching the surveillance video. Never tested Holder's for .40 caliber against the scene cartridge, never examined Holder's phone, allowed Westfall to delete his phone data before turning it over, ignored Trooper Winter's recommendations that Holder be re-interviewed after finding Holder's social media posts depicting young girls believed to be deceased with sticks placed over their bodies, and took 6 years to examine Westfall's alibi, only to find it could not be confirmed. A jury that understood those facts would have evaluated the state's cleared conclusion very differently. That is precisely why the evidence should have been admitted and precisely why its exclusion was not harmless. The state conflates alibi accepted with alibi confirmed. Those are not the same thing. The record makes the difference plain. The badge swipe occurred outside Holder's usual shift schedule. The badge was on a public rack, accessible to any coworker, with no way to detect whether Holder had swiped it himself. The HR officer said so directly. Investigators declined to watch the surveillance video that would have resolved the question. Westfall's alibi, accepted for 6 years without examination, could not be confirmed when it was finally tested. These are not the hallmarks of a confirmed alibi. They are the hallmarks of a flawed investigation. Joyner did not require the defense to disprove a third party's alibi before the evidence became admissible. It required only that the evidence tend to make it less probable that the defendant committed the crime. The Holder Westfall ritual killing evidence does that, and the state's mishandled alibi investigation only serves to make the evidence more probative. And before you move on to D, I just want to say there's why they've decided just focus on Holder and Westfall, because it's got a lot of very firm connections, and the more people you start throwing in without direct connections to them, it makes it messy. And I think they felt that this was the cleanest way to go. Just focus on Holder and Westfall and not throw in everybody else. And maybe that's the right decision. As much as I wanted to see some Elvis stuff there, go on to D there.
Yeah, I mean, my problem with it is you're presuming that the state's timeline is right with this. I've never thought that the state's timeline was correct, ever.
Still don't. Right.
Well, that's the point.
No.
It's like you're arguing in such a way that it almost seems to somewhat agree that the state's timeline is correct.
I mean, we don't even know that Bridge guy was the guy that committed the offense. Like, they're accepting that as true as well, because they're calling it Bridge guy's crime scene, Bridge guy's identity.
Yeah. Hold on. Let me see. I want to see something. Damn. All right. I wanted to show this. Like, have you guys ever seen this thing that they found on Holder's Facebook, the image of the two girls who are acting as if they're deceased with the sticks on them? Have you guys ever seen that? And this is like, I mean, it's unbelievable. All right, so D.
I've got that somewhere. I mean,
I've got it. I've got it.
Do you want me to read D while you look for it?
No, I've got it.
And I think it's even in the brief. It's in their original brief.
Well, the thing that I wanted to show from it was like this comment that he makes under it. Like, I had never seen this comment before.
That a friend will carry,
No, that's
hide the bodies.
No, it's like under.
Well, stick it up so we can see what you're talking
All
about.
right, let me get it to where it was. Let me check photos, see if it's right there.
Indy Cindy, member for 5 months, thank you, says stick formations over blood pools meant what? Well, that's exactly why they needed an expert. But it meant stuff. Because
Yeah, I mean, that's what Perlmutter does.
Right.
So, I mean, like at the end of the day, if you want to hear what Perlmutter would have testified to at trial, just go watch our presentation with her. I mean, she gets into all of it. It's one of those things that.
Yeah, but the importance of blood and runes and all that.
Okay. Oh, I have all her stuff in here too. All right, hold on. Just keep reading. I'll find it. I'll look for it.
All right. So D, the court committed reversible error in excluding Tobin's testimony. The state argues Tobin was unqualified because an expert in one field cannot offer opinions in another absent a showing of competency in that field, citing to Pruitt. But Pruitt is an opposite. Tobin was not asked to perform a firearms examination or opine in a field outside of his expertise. He was proffered to explain the scientific community's critique of, I don't know if they call that AFT or they say it outright, AFTE, I don't know, methodology, a subject squarely within his expertise in forensic metallurgy. And then you've got to scroll down, babe.
Okay, hold on. All right, so that's it. So this is it. Okay. And so this is the thing that was on his Facebook. Okay, this picture.
Can you blow it up?
Yeah, I mean,
what's the comment say?
Is it not blowing up for you there?
No.
Like I'm blowing it up on my end, but
no, it's not changing it.
So the comment says, and the comment stated, and can you guys, if anybody knows the exact date of that particular post, the comment says, and a bind rune on her chest. Hell yeah. So, but that's dated February 21st of 2016. I don't know if that's a comment under this particular photograph. So I had never seen this comment before.
Maybe
I don't-
this is,
I don't
could that
know
be a
why I
different
can't go-
post?
Huh?
Couldn't that be a different post?
That's what I'm asking. If anybody knows
I've never seen that thing that you got up there. I don't think.
this,
I don't think so.
this is the thing that they drove down to Georgia or wherever the hell Andy and Matt drove down to get that.
Well, when did the crime
This.
occur?
What?
When did the murders happen? A tree falls in the woods. It says, if a tree falls in the woods.
I don't understand why I can't blow this up. It's so weird. It's like I'm blowing it up on my screen that I think I'm sharing, but it's not moving. Hold on, let me try it again. Share screen. Let me try this. Okay, here we go. All right, so there.
And what date was the murder?
It was the 13th of February, 2017.
2017.
This is before. Like almost just a year and some change prior.
And I think I remember them saying the date itself was significant.
Well, yeah, Perlmutter was. I mean, she had like, every date that was significant in the case, she was able to attach it to some kind of Norse
Where's
paganism type.
which bind rune on the chest are we talking about?
I don't know. Like I can't see up here.
'Cause that one looks like the chest. The other obviously is the leg, but
I don't know.
and her legs tilted. The other one, the other body.
Yeah, it's this comment though. I had never seen that. I'd seen that picture a million times. I don't know, man. Like, I don't know. I don't know where else. I don't know. Like, I've never understood how anybody could, like, in good faith, not think that there was some kind of nexus with this.
It's insane.
It's
insane.
truly insane. It's truly insane.
All right, stick back up the.
All right.
We were on the end of page 44. I'll start that sentence again.
Okay.
He was proffered to explain the scientific community's critique of AFTE methodology, a subject squarely within his expertise in forensic metallurgy, material science, statistics, and 24 years managing forensic metallurgy operations at the FBI laboratory. As a fallback position, the state claims that Tobin's testimony went to admissibility, which is for the court rather than the jury to decide. This argument is contrary to law. Trial courts determine whether expert testimony is reliable and thus admissible under Rule 702. But once admitted, the jury decides whether the expert's credibility and determines whether the expert's credibility and the weight to give her testimony. Here, Tobin's testimony served both purposes. It went to the reliability and admissibility of firearms identification evidence and credibility and weight the jury should give Oberg's conclusions, which were based upon the AFT methodology, AFTE. Allen moved to exclude Oberg under 702, and the trial court denied the motion without hearing. Allen then proffered Tobin to attack the weight and credibility of her opinion before the jury. The jury should have heard from Tobin, and they cite a Virginia case from 2025, excluding Tobin's testimony, criticizing firearm identification methodology, reversible error. Testimony was a question of fact for the jury. So that was a case where Tobin's testimony was excluded, a 2025 Virginia case, and they found it to be reversible error. Finally, the state argues harmless error because Allen had alternatives to impeach Oberg. But By excluding Tobin, the court stripped Allen of his chosen defense, that AFTE methodology is not credible science, and locked him into a narrower one that necessarily conceded the validity of the only physical evidence against him. Allen's fallback witness, Eric Warren, is an active AFTE board member who endorses the methodology. The jury heard a debate about whether Oberg applied AFTE correctly, not whether AFTE is credible. This forced situation of Allen's chosen defense for another is not harmless and affected his constitutional right to present a defense. Very strong.
Yeah. So E, the court committed reversible error by excluding evidence, impeaching the credibility of Allen's confessions. So the solitary confinement video audio, the state argues that Allen's statements in the solitary videos are hearsay because they do not facially pertain to his state of mind, and that the guard statements were also hearsay. This court should reject both arguments. Allen offered the videos to show he was screaming, speaking incoherently, quoting scripture, singing, and making delirious statements about being King Michael, being cryogenically frozen, and starting World War III. There is no, quote, hearsay problem when a statement is offered to prove the fact of the utterance rather than the truth of the facts asserted. Similarly,
so what they're saying there is to prove that the statement was made, not whether it's true or not, just
right,
that it exists, that it
right,
happened.
right, in this world. Not that he actually started World War III, because that hasn't happened yet. So similarly, Allen proffered the staff audio to show how the prison staff talked callously to him despite his obvious delirium. A statement is not hearsay when offered to show the effect on the listener. The state next invokes Sweeney v. State, claiming the audio was a self-serving attempt to enhance Allen's credibility. The state has it backwards. Sweeney concerned a defendant using prior consistent statements to bolster his own testimony. Allen was doing the opposite, using his own words to show he was delusional and undermine his solitary confinement statements. The state's fallback argument that Allen had adequate other means to impeach Dr. Walla and that psychosis is fluid ignores what the audio shows. The argument is not simply that Allen was psychotic on some days. The argument is that the jury needed to see and hear the specific man the state's own doctors were describing as, quote, more organized than he'd been on May 3rd. And to place that clinical characterization alongside the April 28th video of Allen covered in feces, asking to be euthanized, claiming to be King Michael, and singing hymns. Words matter. Without audio, the jury watched a silent film. With it, the jury would have experienced the full scope of Allen's psychosis. The state told the jury that Allen was, quote, more organized the week before his confession. But the jury never heard what more organized actually meant. The April 3rd phone calls. The state played one of 3 calls that Allen made on the morning of April 3rd, 2023, a 5:14 a.m. confession call, and then used Trooper Harshman to characterize Allen as, quote, calm, subdued, and solemn when confessing, showing no, quote, indication of, quote, duress or stress. The 2 calls that bookend the confession demolish that characterization.
And that is very important in that one sentence right there. The 2 calls that bookend the confession demolish that characterization. The state's going to have trouble rebutting that. They made the issue worse. They made those calls more relevant and crucial by their own bullshit.
Right. I mean, Brad argued it hard in terms of the completeness doctrine, trying to get those in. I mean, that's like, I can't remember if they were trying to say that was waived, but there's no way that was waived.
I don't think it was ever mentioned until just now.
Okay.
The first thing
Okay.
I did a control find for when I read the state's brief.
Yeah, they should have
And
been
then the
admitted
defense's
under
brief.
they should have been admitted under the rule of completeness evidence rule 106. The state argues the trial court permissibly excluded the bookended calls, citing Liberans v. State, and then Hawkins v. State. Those cases support Allen, not the state. Liberans provides that Rule 106 may be invoked to 1, explain the admitted portion, 2, to place it into context, 3, to avoid misleading the trier of fact, or 4, to ensure a fair and impartial understanding of the admitted portion. Hawkins adds that a Rule 106 is, quote, limited by fairness. And where calls are distinct and unconnected, fairness does not require their admissions. So in Hawkins, the defendant sought to introduce other jail calls simply because the state had played some calls with no internal connection to the admitted recordings. The court found no fairness basis to require their admission. In Liberans, the omitted January statement from a separate interview conducted 2 months before the admitted March statement, and the March statement contained only an oblique reference to the prior statement. This case is the opposite. The 3 April 3rd calls are not distinct conversations. They were interlinking and cross-referencing conversations within a 5.5-hour window. In the 3:12 a.m. call, 2 hours before the confessions, Allen told his father that he did not know, quote, how much longer I'm going to be lucid, end quote, and warned that he could not vouch for what he was going to say going forward. Quote, I don't know what I'm going to say. The admitted confession call references this call directly, making the 3:12 a.m. call not merely contextual background, but genuinely explanatory of the admitted call's content. In the 8:45 a.m. call, 3 hours after the confession, Allen asked his wife, quote, did I call you this morning? End quote. When she confirmed that he had, he said, quote, I had the worst dream last night, end quote. He could not remember having confessed. After all 4 Liberans factors are satisfied here. Fairness required their admission. Without the bookended calls or the bookend calls, the jury heard only a confession. With them, the jury would have heard a man who warned his father that he could not vouch for what he was about to say and who later could not remember confessing.
All right, 3. Gracian, is that right?
Yeah, Gracian.
Gracian's foundational testimony. At trial, Dr. Gracian testified that Allen suffered from delirium. When Allen asked Gracian about the observations that formed the basis for his opinion, the trial court prohibited him from answering. That ruling was error. Yes, it was. Rule 703 provides that an expert may base an opinion on facts or data the expert has been made aware of or personally observed, and, quote, may testify to opinions based on inadmissible evidence, provided that it is the type reasonably relied upon by experts in the field. And that's quoting Rule 703. Gracian reviewed phone calls, IDOC records, solitary confinement videos, and transcripts of Allen's statements, the type of material a forensic psychiatrist routinely relies upon. Rule 703 entitled him to identify the specific observations from that review, including statements Allen made that were objectively false as the clinical foundation for his delirium diagnosis. The state argues Allen waived this issue by failing to present Rule 703 below. The argument fails. A defendant preserves an evidentiary error by making an offer of proof, which need not be formal. Again, citing this Allen v. State case. An attorney's explanation of the evidence sought to be proved is relevance, and the answer to the objection is sufficient, citing, looks like an Indiana Supreme Court case from 2005. At sidebar, Allen's counsel explained that Gracian was prepared to testify that his delirium opinion was based on Allen's making statements, quote, clearly not consistent with the facts, and, quote, patently false, including the claim that the girls were shot. The trial court was plainly apprised that Allen was offering to show the jury the observational basis for Gracian's diagnosis. The issue is preserved. Thank goodness. Glad to hear it. Thank you. Preserved. Rule 704B and Kincaid v. State, 2021 Indiana Court of Appeals case, do not apply. As Kincaid explains, Rule 704B prohibits opinions on the truth or falsity of allegations, contested factual claims, whose truth the jury must determine. The question here was categorically different. Whether objectively false statements Allen made, e.g., statements whose falsity is not in dispute, were among the observations forming the foundation for Gracian's delirium diagnosis. That is not an opinion on the truth or falsity of the confession. It is a clinician identifying the observable symptoms that support a diagnosis. Precisely the specialized knowledge Rule 702 and Miller v. State say expert testimony exists to provide. Gracian was entitled to answer.
F, the data on LG's phone is consistent with human interaction at 5:45 p.m. and the state's impermissible rebuttal was harmful error. Stacey Eldridge, a former FBI analyst, found data consistent with a person interacting with LG's phone at 5:45 p.m. An incoming call arrived milliseconds before a wired headphone cable was inserted into the device, silencing it. The state concedes that the trial court impermissibly allowed the state's witness to impeach this testimony with Google searches from anonymous troubleshooting forums. The state resorts to arguing harmless error on two grounds. There was no movement on the phone at 5:45 p.m., and the purported interaction coincided with the height of the search for the girls. Both arguments fail. The phone showed no steps, not no movement, and a person can interact with a phone without logging one. The search
Without logging one? Without logging.
logging a step.
Okay.
The search began sometime after 5, before the crime scene was located, precisely when someone with access to the phone would want to silence incoming calls. The harmlessness argument also misses the deeper point. The state's theory requires a single killer who committed the murders, left the scene, and was seen by Carbaugh walking west on 300 North at 3:56 p.m. But if someone was interacting with LG's phone at 5:45 to silence an incoming call, that person was at or near the scene 2 hours after Carbaugh's sighting. A single killer cannot have been seen leaving at 3:56 and still been with the phone at 5:45. Eldridge's finding is not a credibility dispute about phone data. It is direct evidence contradicting the state's all witnesses saw the same person timeline. Carbaugh did not see the killer leaving because the killer had not left yet.
I just want to pop in here that I kind of hate them saying that it was for the purposes of silencing an incoming call. That's not necessarily what the purpose was. The purpose, very well, they might not have been deceased yet. And the purpose may have been to, have a conversation with your cohorts and block sound from a living person, or I don't know, something else. So I hate them boxing it into the killer was trying to silence the phone. Like, how did he know it was about to ring?
I mean, it was I think it happened after it rang, but that would have meant that they had to have.
They're sitting there ready to go.
Like an aux cord or, headphones handy. So without the internet forum hearsay, the jury would have had Eldridge's findings standing unchallenged. Findings that properly understood do not merely undermine the step data, but unravel the state's entire timeline.
G, and so this is the last of the 7 things that they mentioned. G, the trial court committed reversible error in denying Allen's motion to correct errors. Weber testified he clocked out at 2:02 p.m. and drove 20 to 25 minutes home. The state presented the arithmetic to the jury in closing. Weber, quote, got home sometime around 2:30. His van appeared on the private drive. Quote, at the exact time Richard Allen would have been there with the two girls. And that was, quote, something only the killer would know. Weber was not on his private drive before 2:44. His testimony was demonstrably false, and the state knew it. The 14th Amendment is violated when the prosecutor knowingly solicits false testimony or knowingly allows it to go uncorrected, citing to Glossip and Napui. The state claims, wait, give me one second. Oh yeah, Glossip is in here too. Okay. Okay. Let me get back to where I was. Sorry. All right. The state claims Allen's falsity argument is predicated. Sorry, I was going up to make sure I was at the right place. The state claims Allen's falsity argument is predicated on an unreliable surveillance video. Not so. It is predicated on the state's own FBI subject information sheet dated March 3rd, 2017 in the state's possession, which states explicitly, quote, Weber's phone pings two parents' address overlooking crime scene initially at 2:50 p.m. The surveillance footage Allen presented in his motion to correct errors merely corroborates what the state already knew. Weber's testimony was false. The state suggests Weber's testimony was not demonstrably false because he never testified to an exact time of arrival. This misreads Napui. Weber's testimony was false because he represented he drove directly home, not because he gave a precise arrival time. The state did not merely fail to correct the misrepresentation, it exploited it. Trooper Harshman corroborated Weber's account step by step, confirming Weber's 2:02 clock out and testifying that Weber told him in August 2024 he drove the white van straight home and that this, quote, absolutely fell into place with Allen's confession detail. The state converted an imprecise false statement into a precise corroboration of guilt. The state claims Allen waived his Napui claim. A defendant waives Napui only if he knew the testimony was false, but, quote, made no attempt to demonstrate its falsity. Allen made 6 attempts. The state obstructed every one. Allen attempted to impeach Weber with a prior inconsistent statement. The state objected. It was sustained. Allen attempted to show Weber had motive to lie as an early suspect or person of interest. State objected twice. Both sustained. Allen subpoenaed the FBI special agent who prepared the report documenting Weber's inconsistent account. Testimony quashed at state's request. Allen attempted to elicit Weber's prior inconsistent statements through Agent Christopher Guti. State objected. Sustained. Allen recalled Weber directly and attempted to impeach again. State objected. Sustained again. The state solicited false testimony that inculpated Allen, used its own officers to make the testimony sound even more inculpatory, and then actively resisted Allen's attempts to correct the false evidence. This was a blatant Napui violation.
4, the errors were harmful, whether considered individually or collectively. Before law enforcement even talked with Allen, they jumped to the conclusions that Allen murdered AW and LG because he told Detective Doolin in 2022 that he saw 3 girls on the Freedom Trail and 4 girls, RV, BW, what was that one? I something, and then AL. Though, thought they saw a bridge guy on that trail.
So, right, he said he saw 3 girls on Freedom Trail.
And 4 girls thought they saw a bridge guy on that trail. So in Detective Mullen's mind, that means Allen had to be the guy. the 4 girls saw, and thus Bridge Guy. But RV, really Voorhees, and her friends alleged Bridge Guy's sighting is uncertain evidence. The girls could not have, or the girls could have been wrong that the guy that they saw was Bridge Guy. And even if they did see Bridge Guy, it does not allow, or it does not follow that Allen would be that guy. Regardless, law enforcement tunnel visioned on Allen when he could not remember where he parked and what he wore 5 years earlier. Law enforcement pushed him to say what they wanted him to say. Across 2 recorded interviews, one before his arrest, one after, Allen consistently and emphatically denied guilt. He insisted he was not Bridge Guy, declared that he had never met those girls, twice repeated, "I did not murder 2 little girls," and denied 17 separate times that the casing at the scene came from his gun. To get a warrant, they ignored that Blair, the only eyewitness to the man on the bridge, described someone different than Allen and his car. They ignored that Blair said the man Carbaugh saw was different than the man she saw. And they lied about Allen's admitting he wore a blue jacket. They abandoned the obvious theory that more than one person did it. They ignored the oddness of the scene and the sticks and the fact that Allen lived and worked in a community for 5 years, contacted law enforcement proactively to help, and cooperated fully. 5 days after the murders, Allen gave law enforcement the unique identifying numbers for the phone they now claim he was trying to hide. They confined Allen, who had never been arrested, in the most solitary and restrictive cell in Indiana. When Allen predictably deteriorated, the state mocked his attorney's concerns about his health while collecting psychosis-induced confessions. The IDOC and eventually the trial court, at the state's request, ignored the I-pass order and settlement showing that solitary confinement caused the very mental illness that the state was now exploiting. And at trial, Allen was not permitted to tell his story of tunnel vision into the wrong man. The jury never saw the sketch of Bridge Guy that clearly was not Allen. The jury was not permitted to hear about a ritualistic explanation for the scene that even the state considered prior to Allen. They could not hear about how the state failed to thoroughly investigate paganists with connections to AW and bloodletting rituals, nor could the jury hear the very science upon which the state was asking them to find that Allen's gun was at the scene was unreliable and untrustworthy. This is especially troubling when the prosecutor argued the state's firearm analysis had never been wrong.
Yeah.
The jury never got to hear Allen's tangential, pressured, and delusional speech to show his confessions were not reliable, despite a parade of state's witnesses claiming that he was lucid or faking. The jury was misled to believe that Allen knew a fact that only the killer would have known by presenting false evidence that Weber came home at a time that, quote, absolutely fell into place with the state's theory of when Allen would have crossed the water with the girls. Allen's conviction is based on a one-sided story. The state was permitted to build a tight timeline based on 4 girls, Blair, Weber, the phone data, and Carbaugh, only because Allen was prohibited from impeaching each piece of evidence. If even one of these is wrong, the state's entire timeline unravels. With Allen's hands tied, the state's timeline went from superficial inference stacking to hard facts corroborated by confessions in a firearms match. Had the jury known all the evidence that impeached their timeline, firearms science, and Allen's mind at the time he was in solitary, there is more than a possibility the jury would have acquitted him. The state has failed to prove beyond a reasonable doubt any one error, let alone the cumulative weight of all of them. Did not contribute to the verdict. Chapman v. California. It has been said that a, quote, half-truth masquerading as a whole truth becomes complete untruth, or becomes a complete untruth. The only way our justice system works is if the jury hears the full truth. Because the jury only heard half of the story, Allen was denied a fair trial.
Wow.
There it is.
That is one hell of a brief.
It's a good brief.
It really, really is. It really, really is.
It's a spectacular piece of legal writing. Yeah.
Go through some of the questions. I've got to run real quick. I'll be right back.
Okay. All right, let me pull that down. Okay. Free Ricky Bay, new member. Oh, family hug. Welcome, welcome, welcome. Who's your girl? Member for 20 months. Thank you for your constant support. We appreciate that so much. Casey at the bat gifted 20 DD podcast memberships. Thank you so much, Casey. And I'm sure everybody that was the beneficiary of that was very excited about that as well. So thank you so much for that incredible generosity. Little Sea Star, new member. Oh, family hug. Welcome, welcome, welcome. Recovery Cat, Canadian $10. Appreciate you guys. Appreciate you. Thank you so much for the support. We appreciate it. Christy Silo, member for 9 months. The goal ended already. Bob restarted. I did. Thank you for letting me know. The lovely Ann Piccolo, $5 solid. Restart the goal, please. It says ended. I did. Thank you for letting me know. She Boogies, member for 17 months. Lick'em Low Liggett. Damn Skippy. He's housing some lemon pound cake right now, I bet too. And Piccolo, $4.99, reading the whole damn thing, which we did. And thank you for that. Always, Ann. Petty, please, with sugar on top. Love catching you all live. Well, we're thrilled that you can make it. And thank you for your generosity. Casey at the bat. Oh, word. Let's go. $5. Thank you. Appreciate that. Mama X. Family hug. Yes, to all of you. Thank you for your generosity. D nice to me. $5. So glad I found this site. You guys are the best. Well, thank you so much. We are equally happy that you found us. So welcome, welcome, welcome. RMS, Mass Injustice. Grifting the night away. Have fun at Jazz Fest, y'all. I still need to pack, and it's 11:18 for us. We have a 10:30 a.m. flight, so we'll make it happen. Had to do this before we went. Like, I couldn't let this hang out there in the ether until we got back. It would have been crazy. Thank you so much for your generosity. Jaded for Justice, Canadian $7. Thanks for making me fall in love with the Defense Council. You two are the best. Next year, amazing mods, of course. Agreed. They are fabulous. And thank you so much for that, Jaded. Bailey B, $10. It's time for real justice for Abby and Libby, and to free an innocent man who was failed and broken by the very system that was meant to protect him. Well said. Very, very poignant. Thank you so much for your generosity, Bailey, as always. She Boogies, $5. Betsy Blair and the 4 girls saw Daniel Pearson. Psst, pass it on. I've been hearing that. Thanks, Spoogs. Kay Helly, thank you for your continued fight for Rick and justice. Have a blast at Jazz Fest, and I'll totally watch Bob's lives from down there. Might do it. I might do it. If I can get a signal, that'll always be the key. Like, some of these rooms on these late night shows are like sweat holes, packed with people, can't hear shit, but we'll see. If I can do it, I'll do it. Thank you so much, Kay Helly. We appreciate it. Fire breathing bitch queen. Love that. $5. Appreciate the generosity. Amanda, past my bedtime. We'll replay crew it. Bummed to miss chatting with the cranks. Free Ricky. Yes. Thank you so much, Amanda. When you see this tomorrow morning, Frizvold, $5. Thank you so much, Frizz. We always appreciate you. Military Mama, $5.85. Desperately wanted to hear about the Studi case. Love you guys. Enjoy Jazz Fest. I'm sure we will. Thank you so much, Military Mama. Jade for Justice comes back with some enormous Canadian $140. I don't know what that equals in American, but who cares? It's a big number. Thank you so much, Jaded.
It's like just about $100, I think, in USD.
It's incredibly, whatever it is.
It is $100, so it's very
right.
generous.
Super generous. Thank you so much, Jaded. This goes towards the bottle. We will all watch you pop when Mr. Richard Allen is free. Can you taste it? Free Richard Allen. Thank you so much.
I wish I could taste it.
We will. Think positive thoughts. The Sassy Desk Diaries, new member. Family hug. Welcome. Sassy. Here, you want to read a few?
All right.
I left that name for you there. It's
Jadzia Dax. Jadzia Dax
all right.
is what I'm going with. Member for 14 months. Thank you for your continued support. 3 a.m. in the UK, but I had to drop in to say hello to the fam. We'll replay later. Love this channel and your passion for justice for Richard Allen and others. Well, thank you. And then we have Critical Thinker. Thank you for your generosity. If I see you guys at Jazz Fest, is it okay to say hi? Yes, it is.
I said, of course it is. We'd love that.
Sarah Mess, thank you for your generosity. Says, have an awesome weekend, Matas. Free Ricky. Yes, thank you.
Thank you, Sarah.
Dr. Russell's gasp. Says, I'm late, but I hope you all have a great time at Jazz Fest. And thanks for your generosity.
Thank you.
Shelly J says, so been looking forward to this. Thank you. Please, where are we at the 24-month milestone? Is that like for getting a badge or?
Yeah, they get the OG necklace.
You got to come up with something.
That is it. It's the OG necklace. It's a real thing.
Oh.
We made it. It's there. It exists.
Oh. Yellow Jackets, thanks for your generosity. I read these.
Yes, thank you, Jacket. We read that one definitely. I think we both posted that one.
So Sinbad came back and said, Bob, during the 3 days of hearing, 7:30 to 8:1, the only defense witness called to establish a nexus to Klein was Detective Vito. That was not a serious effort. They called no witnesses to connect Logan.
See, but Sinbad, what you're not taking into account is they waited for that for the last day. Like Baldwin was so panicked because that was it. Like Gull set those 3 days. She was not giving one more minute. And if he couldn't get it on, it was done. Like it was crazy. It was an absolutely limited hearing. He was completely handcuffed. I mean, like I couldn't believe that there was nothing put on for Elvis Fields.
Yeah.
You know, I mean, the Klein stuff was by far the most thorough. And, you know, Logan was short shifted.
All right.
You know,
Majesta.
but no one else was even brought up at all.
Majesta Bishop, hopefully you can answer this question. And thanks for your generosity. And thank you for your generosity, Sinbad. Your multiple,
Yes. Thank you.
your multiple supers. Says every witness picture video assumes bridge guy came from only one side of the bridge. Did they ever challenge or theorize bridge guy coming from the other direction at trial?
I have always had that theory.
But was there anything
No.
at trial? No argument at closing, no.
I don't remember that being the case. No.
Right.
I mean,
And that
I always thought because of the 207 picture of Abby and nobody in the background, I always thought, and it doesn't jive with whoever Betsy Blair saw.
I think that 207 picture, like when we watched the video, showed that it was like the angle that somehow there was no one in it, but there was someone in it.
No, dude, you're
mixing
you're
things
thinking
up?
the wrong thing. Yeah, no,
Okay.
this is the one that they couldn't find on anybody's phone.
Right.
Just Abby, and it's
Yeah.
just a still. It's not.
But
a
to
video.
Majesta's point, that's why I was saying when we were reading, like I hate that they're even saying that bridge guy is the killer because we
Right.
don't know that.
I've always thought that the killer came up from the south, from behind them, not from in front of them.
Yeah.
Like that's always what I've thought, and that they went back towards the north,
Yeah.
and then up and over, not down and across the creek. Because you remember that area, right?
Yeah.
When you walk to the north side of the
And
bridge,
it could have gone down where those women were going to the bathroom.
or you just walk up like that area. Like you can
Right.
get up there and then it'll just take you down. Then you're across the creek. Like,
Right.
there's no crossing the creek.
Mhm. Love you guys. And sorry. Christina MGW says, love you guys and thank you for all you do. Thank you for your generosity. Gray Space, new member.
Aw, family hug. Welcome,
Thank you.
Greg.
Welcome. Bean X, just need 2 more super chats, y'all. Do it for Bob.
It's Phoenix.
Bab. Oh, Phoenix. Sorry.
Yeah, it's creative.
Free
Thanks,
Ricky.
Shane. Appreciate
Bean.
it. Appreciate it so much.
Jaded for Justice says, for goal.
Oh,
Thank
yay.
you for your generosity.
Thank you.
Spin Cycle, thank you for your generosity.
Thank you. Thank you. Thank you.
Indy Cindy, if states right, where did they ever go up 2 flights? It makes no sense.
Makes no
State's
sense.
not right. So your point's well taken. And then Sinbad says 136 pages, Frank's motion, no mention of Logan or Klein.
I mean, you don't have to sell me, not so much on Klein, but Ron Logan. I mean, I'm with you. I'm
All
with you
right.
on Ron Logan.
And then, oh, Pokemom says it exists. She's got so where is it? Remember for 27 months that she's got this.
The OJ, you got to be on YouTube to see it.
Oh,
All right. And we had a bunch of lovely Venmos that I want to read through real quick.
Yes, we love our Venmo. We
Um,
love all of them, but
so Kia says, you two are gems. Thank you so much for everything that you do. Enjoy NOLA and go to the gumbo shop and get the gumbo trio and skip Cafe Dumond and go to Cafe Beignet. So we've been to New Orleans like 50 times. Like, you know.
I don't know if we been to that gumbo spot you mentioned.
Oh yeah.
Oh,
Definitely.
what was it called again?
Like the only time we'll go to Cafe Dumond is if like we have a noob. Like we brought Scout
The
over
kids.
the summer and we, you know, it's kind of
Well,
like
we're trying not to eat those sugar powder, covered in
Oh, yeah.
sugar treats anyway. So
yeah, exactly. So, but thank you so much for that, Kia. We really, really appreciate that. And she said you won't regret it. Okay, and then Michelle. Disgruntled Pelican, sorry for doxing you. Thanks for the continuing coverage on Rick Allen. Excited about the oral arguments. Whenever those may be. Have the best time at Jazz Fest. Jealous that I'm not there this year. NOLA is the best. We agree with that wholeheartedly. Absolutely. And thank you so much, Disgruntled. Let me make sure. $5 from Lori to the voodoo that you do. Thanks to you both. Appreciate that. And then Christy sent $10 saying Starbucks running NOLA. Thanks for all you. Thanks for all you and Allie do. Thank you so much, Christy. And then Kim, our daily angel. Thank you both with an exclamation point today. So thank you so much. She's our daily Venmo angel. And then LM McCallie girl, L McCallie girl. Free Rick Allen. Thank you for never letting this case go. $25 solid. Thank you so much, L McCallie. We love you for your constant support of the show. And then Bailey was all over, and she had said sending before the stream even starts, she's making a motion for members only where we can submit voicemails, questions, messages in a bottle, and whatever medium, because I think I read this earlier, whatever medium preferred, because I have enough for at least an hour-long stream, which I know to be true. I know to be true because she's always DMing like millions of questions. So she's got questions. She's got questions. And I think that's something that obviously needs to happen.
Yes.
And then Laura came through, said, I don't always agree with you, but you have helped me look at cases through a different lens. My dad used to tell me the defense attorneys are the unsung heroes. And I think she sent this last night, but I didn't get to it. He was an attorney, but not a defense attorney. He worked in Moscow. And I'm assuming that's Moscow, as director of the rule of law program. So that was cool. I sent her a nice thank you message. So I think that'll do it for the Venmo.
You own the people a story now.
Okay. So if you guys haven't seen, so this thing just dropped on and it doesn't seem like it's getting the traction I thought that it would. And it doesn't seem like Paramount Plus is like really kind of putting it out there like I thought they would. I thought they promoted a lot more. But at any rate, it's this story about this insane story about this woman, Lucy Studi, who's claiming that her father, Don Studi, during the course of her childhood, had unalived somewhere between 30 and 70 people. Huge gaping number, giant gap there. And like when that story came out in Newsweek, I was like immediately, I think I just finished the Gacy season. It was probably like 3 episodes into Garcia. And, I'm like, oh my God, like we have to get in touch with this woman. I got to see what's up with this because this is an insane story.
And after he tells the story, we'll hop over to PayPal because we got one on PayPal, but go ahead.
So at any rate, I'm like trying to cook up a way to get Lucy to, either return our call or to answer the phone when we call. So I tell Allie, I'm like, look, I think you need to call her and just, say, hey, I wanted to give you some advice. I'm a criminal defense attorney. I don't know that you're worrying about any kind of potential liability, criminal liability, because in the Newsweek story, she had talked about how her father had employed the children to help move and dispose of the bodies. So I'm like, that's kind of like a good angle that you can try to maybe get her to call if she did have those concerns. So Allie, of course, does what Allie does. She's in the car. And I forgot, like, I think Allie dug up her number somehow, like doing what Allie does, found the number, calls her. And then I think she sends me a text and she's like, I got her. She's like, I'm talking with her on the phone. So I'm at the house and I'm like, oh my God, oh my God. So like Allie walks in probably like 15 minutes later. She's in the middle of a deep conversation with Lucy Studi. And I'm tailing her at this point. So Allie's a pacer when she's on the phone. She's talking. I'm following her around. I'm trying to whisper. I'm like, like me. So Allie finally like gets to a point in conversation where there's kind of like a natural way for her to kind of say, hey, well, because she had been talking about the podcast.
And she was saying she wasn't talking to any like creator. She wasn't returning anybody's calls. She's not talking to a single soul, but she's going to tell me as much as she can tell me. She's very talkative. So she's was actually very talkative gal. A lot.
She's a very talkative gal. So eventually Allie asks her, is like, would you mind if I pass you off to Bob? And she agrees to it. And then, I get on the phone and I probably talk to her for another hour, just kind of like telling her what I do and kind of going through like the entire thing about the podcast and how fascinated I am about her story. And, if there's any way that we could help her or, if there's any way that she'd be agreeable to us doing a podcast about it, because we do investigative podcasts. We're deep divers. We'll help her in any way possible. So like that, like I hang up the call without any kind of real commitment. And then she starts texting me like right away. So I know she's into it. You know what I mean? I know. So over the next like 2 months, I probably have like 60 hours of phone calls with her. Right. And it's like,
I got a lot of notes from that first call. Like,
oh yeah. Well, I was taking notes left and right. I mean, I was like, cause like my thing is I wanted to know if she was lying or if she was telling the truth. And so what I was doing in these phone calls, she'd tell her stories and I'd always be looking for inconsistencies or other
consistent.
She was always very consistent, if not completely consistent with all of her stories. And the thing that had struck me as making her credible in terms of her story was the fact that her outcries as to what her father was doing started way back when she was a child. And she had outcried to teachers and she'd made outcries about her father doing this to clergy, to law enforcement. And, but at that point, I think her mother was deceased, which she had died under very unusual circumstances. I think the thought was, or the story was that she had somehow taken a shotgun and unalived herself through the, through the side of the head. So you have to understand this dynamic with the shotgun here didn't make any sense. So I'm like, wow, this is insane. So like ultimately, Don would keep showing up to all the places where she was making all the outcries. And he'd say, well, my daughter's a storyteller. Don't worry about it. It's like, she's just talking trash. So like no one ever gave her any mind. And that went on for her entire life. And she continued to try to get people to look into this all the way up until the time that I met her. So it goes from her being a little girl trying to tell people what her father was doing to her being 52 at the time that story goes. And she never let it go. So I found that to be of great weight. Like I felt that this wasn't like I'm like, if that was a con, it's the longest con I've ever heard of. It's like a child thought of this con way back when. And then we end up going almost, 45 years later, and she still got the con going. And so like ultimately, when Newsweek bites on this thing, she's excited, she's hopeful because she wants to give these victims their names back. She's convinced that all of this happened. And in the meantime, her sister Susan starts messaging me on Facebook Messenger saying that Lucy's insane. If you've watched the doc, you're seeing that this all took place.
And
I'm
the
like,
name I think was Don Studi, the Green Hollow Killer, or my father
no,
was.
my father, the killer, the Green Hollow Murders, I think is what it's called.
Oh, here.
Yeah. So ultimately, and I'm not going to give it all away. I just wanted to talk about kind of how I got involved with this case, because I was very, very involved with it. So I don't know if I made the doc. That's a later part of the story. That's a much later part of the story. And so I think it's in December, or it might be, no, it was during Jazz Fest, right? The first time
When
I
you
went.
left, yes.
No, but when
No,
was the
you went.
first
No.
time?
I've got texts on that. I was looking at them the other day.
Well,
Like,
it's on my TikTok, because that was before
Yeah.
I started the YouTube. So
Yeah.
I go down. So she calls me one morning and she says, I have it. And she's living out of state at this point. And so like far out of state. And so she calls me and she says, I have it from my people in
February 2023.
Yeah, in like the Tabor area, that they just saw a long line of black law enforcement looking SUVs heading towards my property. She's like, I think they're doing the dig. And I'm like, well, have you ever like spoken to anybody to confirm that? She's like, no. She's like, but I trust these people who are calling me. She's like, I can't make it down there. It's too late. I'm like, I'm jumping in the car.
He gets in the car. He's on his way.
I tell Allie, I'm like, well, first I'm like, you got to bring me. I'm going to rent a car and I'm going to head down there. Yeah, I would not be surprised. There was some shadiness that went on with the documentary in terms of.
And this is a teaser for what happens when he gets there. You're
Oh,
gonna
yeah.
hear that. You're gonna hear that on another live.
Yeah,
But
yeah.
go
So
look at
so
the.
I end up making the drive, and then yeah, like and when I start like kind of divulging this whole story and all the background, it's insane. It's an insane story, and
We're gonna get to it when we get
it's one
back.
worth telling.
So look on PayPal while I read Pam Cake's question. So Pam Cakes, thank you for your generosity. Late to the party. Sorry if already asked. Will they have a chance to orally argue this in front of judges? So they did file a motion requesting an oral argument. And I can't recall, you guys out there did, I think Michael said that this is the type of case that he's expecting them to do oral argument on this case, but I can't be 100% sure. Does anyone out there remember what Michael's thought process was?
He's pretty confident they're going to get the oral argument.
Okay.
So Mary Weeks, she says, oh, my mom passed away 5 years ago this month. Well, happy heavenly birthday to your mom. When Allie said Bura, it sounded exactly like my mom and made me smile. Oh, that's so sweet. Have a great fun time in NOLA. And she sent us $10 via PayPal.
Thank you
for
for your
much,
generosity. All right, we got a pack.
Wait, Roberta just sent 25 on Venmo. She said, listening to Delphi, but please look into Fossler from Aaron Spencer. Fossler was a pedo pig and traveled back to Indiana. Hold on. You know, we're all into Spencer, right?
Maybe she's saying, could Foster have been involved?
Oh, wait,
Could
is
he
that
be
what you're
bridge-
saying?
It seems like it.
Is that you're saying that you think that Fossler's bridge guy?
He
I
went
mean,
to Indiana.
maybe. I know.
Again, we don't know if Bridge Guy is the guy.
Hold on. I want to read this entire message. You know who I thought looked exactly like Betsy Blair's thing was the whatever the Devil's Lake, that kid who turned out he was in Illinois and was like 20 years old when this took place, when Delphi happened. Look at the picture of that kid. I forget what his name is. Like the Devil's Head Lake, you know, the kid who like allegedly killed the hikers in the park, the man and the woman. I'm telling you, that dude looks exactly like that dude, like Blair's sketch. Like I was obsessed with it. I'm like, holy shit, I cracked it. I
Yep.
cracked it. I'm like, it's this, like, and then I started digging and I'm like, was he in and around Chicago? And I come to find out he grew up in the burbs
Wow.
and was here until he was 20.
Was there more to her message? Because we do have to start packing.
Wait, is that Daniel Pearson? Is that the dude? So when you guys are saying Daniel Pearson, I've been saying that, like, I have proof that I think that it's him from my Twitter. I've been saying that for the minute that happened. And I'm like, oh my God, that's the sketch. That's the sketch. Yeah. So that's who Daniel Pearson is. All right. Thank you. I could not remember his name. Like I'm constantly sending it to people. And like, I just looked him up again, like a month ago, because I will not let that go. Oh, so wait, let me finish the Fossler thing. So Roberta had said, I want to read the whole comment. She said, Foster was a pedo pig and traveled back to Indiana. It could be pedo ring. I really feel that sicko was involved. So I think you're right. I think she's like implying or flat out saying to look into. I mean, I will. Like, I think, see, we got some, like early on in our Spencer coverage, we had a communication with somebody who had come forward claiming that particular person had been molested. I think she went and did some other YouTube thing. Cause like we like to vet everybody before we put them on the show, make sure that they're not full of it. And then I had it on good authority. So we didn't put her on because she sounded legit, right, babe? I mean, we were both talking to her. Well, I'm talking about the gal who said that Fossler had gotten her pregnant and then followed her to Arkansas. Remember that was her story. I'm like, what? You know, I'm like, and then, you know, I got news that maybe she wasn't being truthful. So, you know, it's like it takes
sounded very truthful.
She
but
really did. Like,
yeah.
and you know, and I ask a lot of heavy duty questions about kind of shit. Yeah, see, like I'm like, we're gonna vet before we're gonna put somebody on because, you know, I mean, there's all kinds out there. There's all kinds out there.
All right, we do have to go pack.
We do have to go pack. We love you guys, mods. Thank you so much for hanging with us for 3 hours, 12 minutes. We couldn't do it without you, and we just adore you so very much. And to all you guys who were incredibly generous tonight, thank you guys so much. You exceeded the goal. You made me so happy, so generous, and in the supers and with the Venmos and the PayPals, all of it. You guys are amazing. We will put the money to good use, I promise. If I can get tickets to the what I really want, the thing that I want most, the show that I want to see the most is the Meter show. And it's sold out. I was looking on PayPal or on StubHub. Insane. They were insane. They were like $500. And it's like, because the Meters is my shit, right? I mean, the Meters are my shit. So, but at any rate, you guys are amazing. We love you so very much. To all the new members, welcome. Please remember to like, share, and subscribe. And if you're on replay, leave a comment. Help get this thing out to the world. And if you have hype points, please use them on this video. We need to spread the word on
the word.
Rick Allen. Let's go. It's like all our mass homies. This case is fucked up. This dude was railroaded. You should care. I know it's
They
not your
care.
state, but care about justice because this thing, it stinks.
Yeah.
Just trust us on it. And we've got so much content you can watch. You can make your own decisions. I'm not trying to hammer you over the head. Go make your own decisions, but go watch how fucked up this thing was from the get, and you'll see what's up. All right, you guys, we love you so, so very much because without you, I'd just be an old man
Sitting around talking to his wife.
and about to bring my ass to Jazz Fest. See ya!